present petition is filed. Present revision is filed. There is a new order.
Page number 12.
12. Yes, yes, please. The agreed with the orders passed in. This thing is number 13 of 2010, dated 18th June 2022. You're the respondent in the respondent therein is before this court. The facts of the case are that the respondent herein, which is the Karnataka State Financial Corporation, had filed a petition under section 31(1)AA and 32 of the State Financial Corporation Act 1951 to pay the loan dues of rupees 5,17,68,704.48 paise due by the principal debtor before the trial court. To that, the respondents, you are the respondent number
2A to 2C.
The petitioners before the petitioners herein or well in the earlier sentence. Petitioners herein are the characters or the character. The original borrowers have filed the detailed objections to the petition. Pending proceedings, the petitioners moved an application under Order 6 or Order 7 to 11 seeking rejection of the plaint. The said application is dismissed. It is a specific case of the guarantor petitioner hearing is that the company to whom the loan was advanced went into liquidation. Where do we get all that? Page number?
Page 35.
Went into liquidation. Before that the petitioner herein has executed a guarantee on 21/3/1980. The said company went into liquidation and the proceedings were concluded in OSA number 29 of 2000 before the High Court. And the company is auctioned by the official liquidator. And the confirmation was on 18/10/2001. And the said amount is accepted by the KSFC as full satisfaction as per the orders passed in the said proceedings dated 4/1/2002. Thereafter, when that was concluded on 4/1/2002, the incident proceedings were initiated by the Karnataka State Financial Corporation for a recovery of an amount of rupees 38,30,310 on 8/8/2005 by issuing a legal notice What is 2005 and legal notice in 2000?
2005 and not like state proceeds. State proceeds of the.
But in the before paragraph it shows as 4/1/2002.
4/1/2002 that proceedings came to be. After that, state proceeds had taken.
On 4, the correction on 8/8/2005. They have received the amount. And further a notice was issued on 24/12/2009. and the instant miscellaneous petition is filed. It is a contention of the guarantor that the the amount was paid on 8/8/2005. The amount was crystallized on 8/8/2005, and the miscellaneous petition is filed. When?
21/8/2010.
21/8/2010, and it is barred by limitation. It is a case that the proceedings are barred by limitation as that they have filed an application under 7 Rule 11. The court, by order in June, had dismissed the said petition. Is that page number?
That page number 12, I was reading that page number 16. It was like 6 years to the litigation, but 3 years. Page 16.
The court, considering section 32(1) small a8 of the SFC and section 32 of the Act and 32(6) of the Act, has come to the conclusion that the payment was made on the payment of rupees 38 lakhs 30,310 was made on 8/8/2005. And the period of limitation is 6 years, and the petition is filed on 21/8/2010. As such, the court felt that the court observed that the proceedings initiated by the SFC, KSFC is well within the limitation and dismissed the application filed by the petitioners who are the guarantors. The court has also observed that Article 137 of the Litigation Act is not applicable to the deed of guarantee, which is a continuing guarantee. As such, that is well within the limitation. Agreed thereby, the guarantor is before this court. When counsel appearing for the petitioner submits that the limitation would start from the date when the defendant have received the amount, when the KSFC has received the amount, and whatever is the outstanding amount is ascertained on that day. From that day, like any other recovery of money proceed, the limitation is 3 years. In that regard, he had relied on the judgment of the full bench of this court in case of Karnataka State Financial Corporation Bangalore versus Jaya Menon and others, reported in 2004 for Karnataka Law Journal 366, wherein it is said that relied on para number 24, the 24 extract. And accordingly, it was held that it is governed by Article 137 of the Litigation Act. He submits that the same was reiterated by a division bench of this court in case of Messrs. Arundhati Laboratories Limited and others versus Karnataka State Industrial Investment and Development Corporation Limited, arising out of miscellaneous first appeal number 200119 of 2015 dated 26 September 2024. He relied on para number 27 and Para number 30. And basing on this judgment, he submits that Article 137 applies, and the limitation is 3 years, and the petition that is filed by them for the recovery of the money is beyond limitation, and all these aspects were not considered by the court. Next paragraph. Then counsel appearing for the respondent corporation submits that the submits that the petition that is filed in that form under Order 7 to 11 is not, it cannot be maintained as it is not a plain but a recovery proceedings that are the proceedings are initiated under section so and so of the Karnataka State Financial Corporation Act. It is submitted that another division bench of this court in Gulati and others versus Karnataka State Financial Corporation in carrying out of MFA number 353353 of 2001 dated 1/3/2006 has taken a view that that the limitation do not apply. Limitation do not apply. It is submitted that in that order, it is also observed that there is a contention of the learned counsel therein that the order passed in the full bench judgment, order passed by the full bench in case of Karnataka State Financial Corporation Bangalore referred supra is per incunium. And in fact, when an SLP is filed before the Honorable Apex Court, the same is admitted. And accordingly, the division bench has taken a contra view. Basing on that judgment, the counsel submits that it is a continuing guarantee and there is no limitation that is applicable, and they can initiate the proceedings, and the proceedings that are initiated by them under the provisions of the Act are well within the limitation. Next paragraph. Having heard the counsels on either side, there is the material on record. The present application, the respondent herein has initiated the proceedings under section 32(6) of the State Financial Corporation Act, under section 31(1)(a) and 32 of this Karnataka State Finance Corporation Act 1951. According to them, the petitioner is a guarantor, and the respondents have one of the, which respondents are the principal borrowers?
One before the trial.
The respondent one before the trial court is the principal borrower, and that company had went into liquidation, and in the liquidation proceedings, the properties were sold, and the amounts were received by the SFC on 8/8/2005. Thereafter, in the year 2009, they have issued a notice, and in the year 2010, the present proceedings are initiated. It is a case of the SFC that it is a continual guarantee, and the limitation do not apply. It is undisputed that a full bench of this court had already held that the limitation Article 137 applies, and the limitation is only 3 years for recovery of the amount. In that case, and the counsel has relied on the judgment of this court in Gulati's, a division bench of this court in Gulati's case, wherein just because an appeal is filed before the Honorable Apex Court and it is admitted, the law laid down in Gulati's case, in a full bench case of Karnataka State Financial Corporation, was not considered. When there is an order of a full bench, and this court has to can only consider the law laid down by the full bench. Now it is also submitted that the appeal that is filed against the order of the full bench is dismissed by the Honorable Apex Court. Basing on the very same judgment, thereafter, a division bench of this court has also reiterated the same in Mrs. Sarundati Laboratories Limited, Refer Sutra. In the light of the law laid down by the full bench, the limitation Article 137 applies, and the limitation is 3 years, as in this case, the respondents have initiated the proceedings under the provisions of the KSFC Act after a period of 3 years, and as such, that is barred by limitation, and the application that is filed by the petitioner guarantor is liable to be allowed accordingly. The order, this court is passing the following order. The order impugnated so and so is set aside, and the appeal is allowed. And the revision is allowed. Yes. Yes.
Last time we had a document for a installment.
Please adjust the mic. I'm not able to hear you. Yes.
In the district court, what has been urged is for the stay of the proceedings. I have filed the objections to the main petition, and I have made myself clear that in case the main matter itself is heard, I am ready to argue, because not on the IA, because if the IA is passed any order, they will come for the stay and they will drag on the matter. This is a matter of 14 years.
When is the impugned order? Let us just look at the impugned order.
The impugned order is for the stay of the proceedings. And stay was rejected on the ground that no substantial grounds have been made out by the petitioner, that what hardship are going to be caused to him if the stay is refused.
Now, what are the facts? Can you please, what are the facts of the case?
This is earlier I was a tenant of the property. Later on, I entered into an agreement with the owner for purchase of land on 17/6/1985. Later on, this property was sold to the respondent on 17/12/1987. But I filed a suit for special performance in one of the 389, wherein one of the
When
suit
was
was
the special
declared.
performance one?
A special performance.
When is it?
It is
391 of ADA.
381.
381 now?
88.
1988.
What has happened to the suit?
The suit was declared. Suit was declared in my favor. The court held that he is not a bona fide purchaser. The respondent is not a bona fide purchaser. Later on, they preferred an appeal. Appeal was allowed only on the ground that I was not ready and willing to perform my part of contract. This is the only finding given by the appellate court. As far as bona fide purchase is concerned, court first has not said anything. The issue regarding bona fide purchase is not bona fide purchase remains as intact. And my agreement has to be proved. Later on, the respondent files HRRP, rent control eviction petition. In that note, I made an application under I number 6, saying that I am the agreement holder, I am not a tenant. Therefore, he may be directed to file a suit. There, it went against me. HRRP also, I filed. That was dismissed. I went to Supreme Court. Supreme Court said, you have got other remedies. Avail other liberty is given to the petitioner to avail the other remedies. I filed a suit for declaration that I am in possession of land as an agreement holder, not as a tenant. Now, eviction order is passed on the ground that he is a tenant of the land. Premises. Now, the HRRP is filed now challenging the eviction order now. I made an application for stay of the eviction proceedings till the HRRP is heard. That is dismissed, holding that I am tenant of it.
You're a tenant?
I'm in tenant road premises. No, nothing survives clause in the HRRT now in a revision petition. As if you are saying you undergo death sentence, I will hear the appeal later on. No, I am only seeking was let the time limit be fixed. The lawsuit can stay the order. I will hear the appeal, the HR appeal will be heard at any point of time. I will ready with them. That is my question.
No, without granting a stay, how can the court, no, first of all, eviction will be ordered and then the final matter will be heard.
That's why I'm seeking for a time may be fixed.
6
Because
months.
14 years I have suffered.
6 months, 6 months.
3 months.
What
Because
is the-
already
what is the
14 years
stage?
have been suffered, no single entry is paid
What is
towards
what is
the...
the stage of the proceedings now?
Pardon?
What
It
is
is for the arguments of India, rent division.
On merit it will be heard.
It is rent division, on merit it will be heard, 1 month time may be granted.
3 months? 1 month it can't be. Court has some other work
Because
also.
if she had agreed for stay, was
Because already
already
these questions have been answered by the High Court. What he is urging now in SRRP also.
The present revision, present petition is filed, agreed with the orders passed and. Where is the included order?
Page number 10. On item number 1.
In rent division.
That's not the order.
No, sir, Alex is at page 51. Date 21 to 20.
Yes. Agreed with the orders passed and. RR number 50 in IA number 2 in RR number 5002 of 2022 dated 1st December 2023. The tenant is before this court. The yes filed IA number 2 seeking stay of the execution and enforcement of the judgment and decree passed by the trial court. The trial court, by judgment and decree dated 11/8/2002, has allowed the petition filed by the landlord under section 27(2)(r) of the Karnataka Rent Act and directed the revision petitioner herein to vacate and deliver the actual physical possession of the petition premises within 2 months from the date of the order, and also directed to pay the arrears of rent. You have paid the arrears of rent?
Yes,
Not paid.
what was I'm in possession pursuant document. I'm not a tenant, that is my basic content. That is the only
The court
content.
has ordered.
Also
That is also permitted.
direct to pay the arrears of rent of rupees 5,040 within 2 months from the date of the order.
And continued rent also issued.
I'll deposit in the court also to the permitted and deposit.
That is the order, continue to pay, no. I'm looking at the order.
Unless the possession is due.
Finance the to the petitioner within 2 months from the date of the order. The court, the appellate court, the divisional court by order in view had dismissed the application seeking stay, that the language of subrule 3 of Rule 5 of Rule 41 CPC is emphatic and imperative, which categorically lays down that no order for stay of execution shall be made unless the court making it is satisfied that substantial loss may result to the party applying for stay of execution if the stay is not granted. In the affidavit enclosed to IA number 2, it is not urged that the petition will be put to substantial loss if stay is not granted. Hence, as the petitioner failed to establish that the substantial loss why he has closed it to the Bangalore thing that they have to, that our advocate will log in, ask him to come and yes. The substantial loss will be caused to him this stay as played in IA number 2 is not granted and accordingly dismiss the IA. Then counsel appearing for the petitioner submits that he has been in possession of the property as a tenant right from
What's right from
1940.
huh?
1940. 85 was the agreement.
Right from 1940, and there is no landlord-tenant relationship between the petitioner and the respondent. In fact, the petitioner is an agreement holder. He has filed a suit for specific performance that was decreed. In the appeal, the same was dismissed only on the ground that the petitioner is not the petition is
He's
not
not
ready
ready and
yet,
willing to perform this part.
ready and willing to perform this part of the contract. The trial court has observed that the respondent is not a bona fide purchaser, and the appellate court has not reversed the finding.
Yes.
Has not reversed the finding. Then counsel submits that he has been continuing in the possession of the property from several decades, and court without even considering the said fact, and without and when the revision is pending consideration, not granting it the stay would cause loss to the party, and the reasons that are given by the court or contrary to the settled law. Next paragraph. Then counsel appearing for the respondent submits that the proceedings were initiated in 1998.
2009.
2000
9.
are initiated in the year 2009, and
22
if the
years.
court had rightly not granted the stay, as it's an old petition, the court, if they argue if they advance arguments on merit, the same would be decided, and decided, and there are no grounds to interfere with the order passed by the court. Next paragraph. It is having got the counsels on either side, there is a mention on the court. The tenant has been there in the property from the year 1940. It is his contention that he is an agreement holder, and that there is no landlord relationship between the petitioner and the respondent. The trial court had decreed the suit. When the revision is filed against that, unless and until stay is granted, and if the judgment and decree is executed, the appeal becomes infructuous. The court, without considering the said aspect, has failed to grant the stay of all further proceedings. In the considered opinion of this court, the order cannot be sustained, and accordingly, this court is passing the following order. The writ petition is filed with the order imputed so and so by so and so is set aside, and the appeal filed by the petition filed by the petitioner is allowed. Next, as these rent control proceedings are initiated in the year 2008, 2009. Considering the facts, these are old proceedings. The trial court shall conclude the proceedings within a period of 3 months from the date of receipt of the copy of the order. No adjournment shall be, unnecessary adjournment shall not be granted.
One submission. The dispute between the landlord and tenant was already settled by this honorable court in HRR 521/30.
Those are
That was
other.
not
It is a contention of the land council responded that already the disputes between the
Landlord
petitioner and the original landlord are already settled by the court in HRRP number
521/30.
521/30. Yes, next. Yes.
It's in respect of maintenance for children.
The trial.
Petitioner is willing to take children along with him. Since he is having very limited source of income, that is an agricultural coolie. Having 58.
What she was saying, she is not interested. She wants him to come and stay with him. Stay in her house. Huh?
She's not willing to go and stay with the husband.
Then we will see. We will pass orders on the merits of it when they are not understanding what is the scope of this the petition and what is going to be the order and what is going to be their fate, and if they stick to that, then the court can't help it.
But the dispute is with regards to the children's lordship.
No, whether it is with regard to the children or the wife, whatever it is, husband should have the, the financial capacity to pay it. Is it not? You can't, because it is not about your requirement. It is about his earning also is important. He's an agriculturist. And not a, he's a daily, he's working, he's a coolie. How will he give all this? How much is granted by the court?
2,500 each, Your Lordship. There are 3 children.
Totally 7,500, madam.
And
Then why, when the father is ready to take care of the children, why the mother, let the mother send the children to him? They take care.
even children are not willing to go with the father, Your Lordship.
They only want his maintenance.
Because of the behavior of the father, Your Lordship, the children are not ready, Your Lordship.
So we will see from the order. If from the order it makes out that he is having enough resources, then we will grant. Yes. We come to the order. Page number.
31.
Hmm?
Page number 31, Your Lordship.
Yes, 31. Read that memo. A memo is filed stating that in view of the changed law against order passed by an education appellate tribunal, only the red petition lies. As such, they have come up with this petition. The petition is permitted to convert this petition, see a revision to a red petition, and the petition is directed to return the entire papers. Yes.
Please, let me.
Yes, next. Permit, that's what it is. So that's what it is. Yes, next. Yes.
Order of the birth title. But I had filed a suit seeking for declaration that the native is the owner of the property. But the initial my submission is since PW1 was examined, thereafter.
Where is the order?
That page 14.
Yes.
Suit is dismissed. Operative portion my lords get on page 28 and 29.
How you have become owner of the property?
But it was earlier property which was not subject matter. One Srimati Hasina Bai was the owner of the property way back in 1949. She was survived by 2 children, whom subsequent to commencement of the Inam's Abolition Act, they had filed a form of one before the tribunal. Tribunal regranted the land in favor of the Inam Das. Thereafter, after regranted in 1981.
When was the grant?
Pardon?
When was the grant?
23/11/1981.
In favor of whom?
Earlier, the children of the owner, Srimati Hasina Bai.
How are you related to her?
I have purchased the property in 2002. Land is converted, tenure of the land is converted in the year 1991, and the assistant commissioner permitted to convert this land, permitted to alienate this land. Based on the permission granted, the property is purchased by the present plaintiffs on 3/6/2002. During the pendency of the proceedings, PW1 was examined before the court, before the tribunal. Since his evidence, he could not appear for cross-examination. His evidence is discarded. In the absence of any evidence, I am requesting first for the remand so that
Will let me look at it.
Yes.
It was declared as a work property on 22/8/1975.
Yes.
How this notification is issued now, if once that all those properties are Inam lands, whoever is there in that, it has to be subjected to the land tribunal, the proceedings
Yes.
under the Inam
Initially, the surveyor has to survey the report, survey the area.
Yes, that's what.
The inquiry has to be conducted. The Honorable Supreme Court in 2021 as well as 2022 say, opined that unless this inquiry is complete.
And the Raichwari Patta is granted in
Yes.
favor of the occupants.
Now, I would rather not going presently, not going to present
which act prevails over the other, whether the Karnataka Sub Inam Abolition Act prevails or the Work Act prevails. Because the central act, this parliament has enacted the Work Act, whereas the Karnataka State Inam Abolition Act, which received the assent of the president, whether which is general and which is the special act. Coupled with the act being placed under the 9th schedule. In respect of these situations, nothing was submitted to the tribunal to come to the conclusion. The notification which was issued by the work code in the year 1975 had not seen the day of time. I cannot say.
No. When, for example, a particular village is a Inam village, and whatever the lands that are there in that particular village, they are governed by a law.
Yes.
They are governed by the Inam Abolition Act.
Yes.
And the proceedings have to be taken under that act. Even, for example, as on that day, if the Waqf is in the position and they say that, then even in respect of that land also, proceedings have to be in the same manner.
Yes.
And then whatever is order.
Yes.
But in this case, why that, what has happened to this, that Waqf notice should have been given to us. And
No.
as of now, no notice.
No notice has been
given
issued to the board.
No, but the thing is, it is given to somebody else. And somebody has a rightwari patta in their favor. And that has to be set aside, or whatever that, what you call it here, I don't know. We call it a rightwari patta. If that is given in favor of some other person, and according to you, it is a notified work and it belongs to you, then that has to, you have to get it. You can only get it set aside by appearing before the very same that authorities, that the Tehsildar would be the primary authority.
In this matter, actually, it is an Inam land, service Inam land, and it is Devasthan Inam clearly written in the revenue records prior to Gazette notification in the work. It is bound by service Inam to the Dargah. If it is a service Inam to the Dargah, then for the pious and religious and charitable purpose, it becomes automatically Waqf Milan. And that matter has been dealt by the Honorable Supreme Court of India in Syed Ali versus AP Waqf Board. That decision is there. So how the land was, how the right of patta extra has been given, what is...
But what happens is, if it is an Inam village, then all these will be considered.
That is true, that is true.
And the proceedings have to be under the Inam Abolition Act. You just like that, you cannot you should notify it as a
the proceedings must be under Inam Abolition Act once it is vested with the government.
So where are the proceedings with regard to this?
That is not there produced by the petitioner.
No, it should be produced by you. Because you say that it is your work plan. And according to them, the rightwari patta is
proceedings I am having not before the Commissioner of Works. The proceedings before the land tribunal I don't have that because they have been granted.
You cannot find any document.
That is the reason
Just like that, you are saying so many things in this.
These are part of the pleading.
No. I'm saying pleading. There should be some document also.
That is the first submission I was, but since he did not.
Well, remind this matter then, because it is an issue to be decided.
With specific direction.
With specific direction.
To hear the matter on clarity. Because it's very old matter.
Agreed with her. Then who is in position now?
Question Dargah is in possession of the property, and after grant of land, they have converted the land into non-agriculture and sold it to the persons, and those persons have filed the restriction.
Agreed with the orders passed in OS number 1 of 2024, dated 27th February 2009. The plaintiff is before this court. The petitioner herein has filed a suit for declaration to declare that the sued property is the personal property of the plaintiff and the consequential relief of injunction. According to the plaintiff, the property originally belongs to one Srimati Hussain B, and she is in possession of the property. She died on 23/5/1949, leaving behind her
granddaughter.
Her daughter.
Granddaughter.
Her granddaughter has her only legal heir. After the death of Hussain B, the granddaughter succeeded to the property and her name was mutated in the revenue records. The Inam abolition, the proceedings under the Inam Abolition Act were initiated, and it's the case of the plaintiff that the Land Tribunal, Haveri, by order dated 23/11/1981, granted occupancy rights in favor of the grandchildren of the successors of
Amiri.
Amir B. And thereafter, they have applied to the Assistant Commissioner for the land to right value and paid necessary amounts. And the Assistant Commissioner, by order dated 29/1/1991, allowed the said application, granted permission to the owners to sell the land. And thereafter, the property was sold to the present petitioner by registered sale dated 3/6/2002 for a valuable consideration of 1,43,000, and their names are also mutated. It is a case of the respondent number. This is the case of the respondents that
Number one, board.
respondent number 1, that this property is a work property and it has been notified by notification dated 22/8/1975
Under section 5(2) of the Work Act,
under section 5(2) of the Work Act,
1985.
and they are the owners of the property, hence our owners of the property. The trial court, the tribunal by order in June had dismissed the suit filed by the plaintiff.
They have heard the arguments also, actually, both the sides.
In view of their own pleadings, Amir B was declared to be the mutawalli of the said dargah, and therefore the vendors of the plaintiff becomes the interested persons in the work. Under the circumstances, the plaintiffs cannot contend that bar provided under section 6(1) of the Work Act 1995 does not come in their way in filing the suit. And the court has come to the conclusion that the plaintiffs or their predecessors entitled ought to have challenged the impure notification within a year from the date of the publication of the notification. In view of the limitation provided under section 6 of the Work Act, the suit is barred by time and is liable to be dismissed, and the court had accordingly dismissed. Next paragraph. Learned counsel appearing for the petitioner plaintiff submits that once it's an Inam village and the proceedings under the Inam Abolition Act were concluded, and a certificate, the right body certificate is granted in favor of the vendors, and the Assistant Commission has also granted permission for the conversion of the land. The petitioner has purchased the property, and the work has no right and title with respect to the said property, and the court, on the ground that within 1 year the said notification is not questioned, has dismissed the suit, and he submitted that right from the beginning the names of the names of the vendors, and thereafter the petitioner's name is mutated in the revenue records. Next part. Then counsel appearing for the respondent work submits that right from the beginning it is shown as a Inam land, and the same is given for the service Inam for the service done to the dargah, and he submits that though they have stated so many as they have taken several pleadings with regard to the land reforms tribunal and other issues, all those were not placed before the court.
Board was not made a party.
And the board is also not made a party. He submits that.
Board is a party. Board is not a party before the land tribunal.
Not right, sir. The submits that. Why will the board be made a party?
Because it was notified in the Gazette, and also it is brought.
They are not concerned with it. They are only concerned with their own inquiry is different. Remove that.
But it's a public document.
Board is not a party that you remove. That what is it?
So if the minutes are not issued in more detail, but under section 20, like shown as Inam land and Inam that should
Not required, that will be, it is submitted that the court considering all these aspects and as they have not questioned the notification within 1 year had right to dismiss the petition. Next paragraph. Having heard the counsel on either side, there is a material non-record. It is a case of the plaintiff that the property is an Inam land and as per the proceedings of the land reforms tribunal, the certificate, the patta is granted in favor of the predecessors entitled of the petitioner. And thereafter, permission was granted by the assistant commissioner and he purchased the property by way of a registered sale. A perusal of the order discloses that none of these documents are placed before the tribunal. As if looking at the pleadings, it appears that these aspects needs to be considered to come to a just and a reasonable conclusion with regard to the with regard to the relief that is sought by the plaintiff. Considering all this court is of the view that an opportunity should be given to the plaintiff so that he place all the documents before the court. And the court can give a quietus to this litigation. In that view of the matter, this court is passing the following order. 1. The order issued dated so and so is set aside, and the revision is allowed. Number 2. The court should decide the same in accordance with law within a period of 6 months from the date of receipt of the copy of the order. The party shall not ask for unnecessary adjournment and court also shall not grant.
Much obliged.
Both the parties are at liberty to adduce evidence, further evidence, and also, if necessary, amend their pleading.
Much obliged.
Yes.
Husband petition, 20,000 is the award interim maintenance.
What is the income?
His income is 80,000.
Who are the petitioners?
Petitioner is the wife only.
Only wife,
Wife.
no children.
No children.
And huh?
2 children plus only wife has filed a maintenance.
She has 2 children.
2 children.
No, 2 children and wife 20,000. You want 80,000. What is wrong in it?
About 2003 marriage was taken place.
You can be little louder.
2003 marriage was solemnized. And 2013 the wife left the matrimonial house without any reason. Thereafter she filed a divorce petition. Wherein I appeared, contested. Thereafter the divorce petition filed by the wife came to be rejected. I filed a restitution petition, which came to be allowed. 2017 divorce.
When was your restitution?
It in the during the pendency.
Decreed. When is it decreed?
It is on 2017.
Then when is this order passed?
This is now 2019. Now a fresh divorce petition was filed and
Now, when there is an order of restitution against you, and you have not joined the company of the husband, and you have not preferred any appeal against it, then what has to be assumed is that without a reasonable cause you are staying away from the husband. If that is the case, you are not entitled for maintenance under 124.
Please, my humble submission is that I also have filed a restitution petition.
No.
In my affidavit.
No, anyhow, what else if that
It
is
was
your
filed by
case?
me,
That's your case. That's all the more good. Then why don't you join?
The only reason is that he's addicted to alcohol consuming, and
You should have questioned that order
please.
of restitution. You have not questioned it. Tell your client that if in these circumstances she won't be entitled for maintenance.
Please.
As far as the wife is concerned,
Yes.
children will deal with the children.
Please. In fact, in her application,
She has not asked for the children.
for the children, mentioning the reason, she has mentioned that it is for the expenses of children.
But unfortunately, they were not made parties.
Please.
Once we say that they are not entitled,
Please.
then we'll do. I'll post this matter on next week. Get instructions. One is she will not be entitled for maintenance.
Please.
Number 2, and if the children are entitled, they have to be implemented.
Please.
They have to be pleaded. For that limited purpose, because you will have the option of getting it from the date of petition, I will set aside and remand this matter so that you can plead the children also. Get instructions. Heard the councils and part list this matter as parted on 9th of December. Yes, next.
Then all these matters, there was Chandrakant Madhav का पढ़िए,
Where is he? No representation for the party in person. But there is no representation on behalf of the respondent. List this matter after vacation, after winter vacation. Winter order only granted is extended. Next.
A week's accommodation.
Weeks accommodation before order. Next.
Yes, sir.
Yes.
Weeks accommodation, my lords, to take, sir.
11/11/2024 order. What is it? I've inserted copy of hand summons as per the order dated 11/11. Why? Why? When there is an order, how can you say that we are not served? The list is matter after vacation. After a winter vacation, at the request of non-council petitioner. Next.
Monday, my lords, because the council for respondent for the trial court was out of town. They have informed me by Monday we will serve it.
The list is matter on 17th of December at the request of non-council petitioner. When did you have you taken?
No.
The list is matter after winter vacation at the request of non-council petitioner. Yes, well.
I said week accommodations to take persons.
Petitioner should take steps within a week or else the default order lists this matter after winter vacation. Yes, next.
Interim order.
Interim order earlier granted is extended and then, yes.
On to attend the hospital.
2022 matter, come on, list is matter after winter vacation at the request of the council petitioner. Yes, next. 14. No representation after winter vacation. Yes.
My lords, submission, my lord. My lords, I was appointed as an amicus curiae in this case, my lords. But the respondent want me to give an assurance that some positive orders should pass, my lords.
Where is
So,
the respondent?
she is not well, my lord. She wants to appear party in person, my lords. So, my name may kindly be deleted, my lords.
Huh? It's all family matters, no? They are only the apex court.
In all these cases, we are quite clear that she is not aware. Even before this honorable court, this honorable court has.
So your name is?
M.A. Makanda, my lords. I was an amicus
It
curiae.
is submitted that this court has appointed the advocate M.A. Makanda as an amicus curiae, but the respondent wants to appear as party in person.
Yes,
Party in person, delete her name and print the name of party in person. You have an interim order in your favor? You have an interim order in your favor? List is marked after notification.
Yes, sir.
Yes, next. Interim order early granted. Yes.
There is a delay in filing the application. Written at 11 days.
What do you say?
Lot of these.
On cost. On cost. Will come down. 2,000.
He is a driver in a BMTC.
So?
5,000 rupees.
No, if you say, when I'm saying 2,000, you say no, you're saying 5,000. Then we'll about 5,000. 811 days is an inordinate delay. The IA number 1 of 2024 is filed to condone the delay of 811 days for the reason stated, and there are no objections are filed to the respondent, but however it is orally submitted, that the delay of 811 is a not a delay and no reasons are stated by the petitioner. This court having perused the order passed about the reasons that are stated in the accompanying of the writ and considering the substantial interest of both the parties, deems it appropriate to condone the delay of 171 days on the condition that the petitioner shall pay an amount of rupees 2,000 to the respondent within a period of 15 days within a period of 15 days from today. List this matter after winter vacation. Accordingly, I number 1 is allowed. Next,
Vice petition.
where is the counsel for the respondent? List this matter on 9 December. No representation for the respondent. Yes, next. 18.
Question not that
Who
arises.
appears for the respondent? Yes.
Question arises for consideration in this case is not said. Decree passed in favor of a person. Not if he was dead on the date of decree.
He was
Deceased on the date of
decree against a dead person.
in favor.
In favor of a dead person.
Whether it's a nullity.
It is a?
Nullity.
Mm.
That's it. But here what has happened is a suit for specific
You are
performance.
for?
I am for the decree holder. Decree holder. Suit for specific performance was filed, not which reached High Court. This another court. In RSA 570
No. Suit for specific performance is filed by you.
Yes.
It is decreed when?
Trial court notes dismissed it.
Dismissed it.
Yes.
When?
On 29/7/1981. When an appeal was filed, appeal was partly allowed.
Partly
Giving a
means?
refund of amnesty.
Oh, refund of the money.
Registered agreement of sale.
Refund of money by order dated, by judgment dated?
10/1/1991. 10th January 91. Against that, a second appeal was filed by the plaintiff in RSA 570/91.
RSA 570.
570/91.
You only filed.
I filed. That appeal is decided on 16 December 97. In the meanwhile, the sole plaintiff, appellant, had died on 17/11/95. Not known to either of the sides, it was unnoticed, and decree remained. The decree holders, legal heirs, file an execution in 21/2009, where EP number 21/2009.
19.
Decree holders, LRs.
2009.
2009.
So from 95 they kept quiet to 2009, they moved the.
Since it has been renumbered.
Ground number 5 of your grounds at page number 4, bottom. How can you say when you yourself are saying right from 2022 they are staying with the husband? Correct, but this is filed in the year 2024. How can you make such a submission? The fact remains is they are not with you as on the date of filing of the petition. Where did you say so? What is that sometime? Now it is they're completely with the father. Look, party should be very careful while making submissions before the court. Now that what it goes contrary to the affidavit you file now. The distance is so and so, and it's difficult for her to travel, and she has no means to travel. Land counsel appearing for the respondent submits that in fact from the last 6 years the children are staying along with the father, and the father is taking care of them, and he has filed the petition for restitution. He submits that there are no reasons made out by the wife seeking transfer of the petition from Dharwad to Dharwad to Belgaum. The same is the land counsel appearing for the respondents of the petitioner submits that in fact the children were forcibly taken away by the husband, and she had filed a complaint before the police. Next para. Having other counsels on either side produce a material on record. In the light of the respective contentions taken by both the parties, the fact remains is that as on today the children are with the husband, and the husband had to take care of the 3 children. And considering the same, and further he has filed a petition for restitution of conjugal rights, and the petition that is pending at Belgaum is the
Restitution is pending at Dharwad.
no. The pending at Belgaum is a criminal miscellaneous number. Considering all these factors, and considering the fact that the children are with the father, this court has not inclined to transfer the petition from Dharwad to Belgaum, and accordingly dismissed.
Please, ma'am.
Admission matters, clear and completely, attachment formality,
I have taken time to file the cancellation of complaint. Grammatical mistake.
List is matter on 16th of December.
Please.
Yes, at the request of one counsel petitioner. Next, 24.
clear number 24, Vishwanath Hegde, clear election. Vishwanath Hegde.
Why is it adjourned yesterday?
To prepare dates of trial events.
Huh?
This matter has a checking history. This is the third or fourth round of litigation.
You prepared or not?
Yes, madam, I prepared. Madam, the list of dates and events.
Huh?
List of dates, madam.
We'll hear it on this matter on 19th of December. This is matter on 19th. Yes, next.
Number 25, Govinda Kavali.
Child court order sheet. Yes, this matter on 13th of December at the request of Land Counsel petitioner. Yes, 26.
Clear number 26. Satyanarayana Kartik, authorized.
Its matter is filing a joint memo once parties are present.
Give that, take that.
There was a decree of divorce operating between the parties, but now they have recalled that he has not pressed the petition manuals. It was ex parte decree of divorce. She filed necessary application, and that came to be recalled. Subsequently, when the matter was there, he has filed application to dismiss the OP as withdrawn.
It is today a memo is filed, and both the husband and wife are present before this court. It is stated that they are residing together at Vijayawada, Andhra Pradesh, and have resolved all the conflicts in between them, and there are no pending litigations between them. And also it is stated that an amount of rupees 63,000 deposited by the petitioner husband
Please.
may be released in favor of the husband. And and it is stated that the petition may be dismissed as withdrawn in the light of the above facts, considering the submission of both the counsels, and in the light of the joint memo filed before this court, the petition is dismissed as withdrawn. Accordingly, this court is passing the following order in the light of the compromise petition filed before this court, dated 28/11/2024. The petition is dismissed as withdrawn, and this compromise memo shall be annexed to this order.
Please, please.
Copy of the compromise.
So, please, read.
Yes.
Yesterday, I observed a copy of the
Mrs. Matter on 17th December, not 17th,
Hello.
18th December.
No, no, short date, no. I am ready with the matter, madam.
Short date is 10th of December.
Please.
Next week code is not there. If you want, I'll give a
No,
date.
no, no, stand.
Yes, 10th. It's okay.
Actually, my petition is questioning the application for rejection of claim was rejected by the trial.
What is the suit for?
Suit was not for not the declaration of title and recovery of possession by the this respondent that is claiming themselves as society.
Yes.
That is named Sri Achyut Ashram. Because earlier they have filed a suit in the year 1995, claiming the same relief, and that suit came to be dismissed. As there is no cause of action in filing. Then that they have challenged in the appeal, and that also in the appeal also came to be dismissed.
No.
And
The earlier suit that is filed is dismissed.
dismissed.
Again, if an appeal is filed, it's confirmed.
It is confirmed.
And no further appeal is
even,
filed.
even in the appeal, in the RFA, your ultimate kindly Karu, in page, there is an observation. It's at my lord's in page, 112 my lord. 112. 112. Para 5 minutes.
114.
112 months, 112.
Yes.
Para 5. In this case, there is no dispute that the properties originally belong to Yogi, who was the founder of the ashram. The plaintiffs are not claiming title to the properties by way of inheritance or as appointed successors to Yogi. They are their title only as devotees of the.
So it is filed by a devotee.
Devotees,
Who
claiming to be
is
devotees.
not the owner of the property, is only a devotee. On that
Yes.
ground, it is dismissed.
Yes, it
Now,
was.
it is filed by whom
And
now?
thereafter, again, the same person, in the further, some liberty was given by this honorable court. In the next slide. However, we observe that the properties, if the properties in question really belong to the trust, as claimed by the plaintiffs and other devotees, can approach the jurisdictional district court under section 92 of CPC for relief, for appropriate relief. This order was challenged by filing SLP.
That is dismissed.
That was also dismissed. Thereafter, they have filed appeal, suit before the district court under section 92.
Filed by whom now?
Filed by the very same persons, very same
Devotee. The
yes,
very same
devotee, very same devotees, claiming themselves as members of the society at a later stage. Initially, they have filed a suit as a society, and thereafter, the observation filed made by this honorable court, they have filed a suit, claiming themselves as trust. Only on the basis of observation made by this honorable court. Thereafter, that suit also came to be dismissed by the district court. stating that there is no cause of action. And apart from that, my lords, it is not a trust. And my lords, that application claiming themselves as trust and allowing them to, my lords, prefer my lords, the suit came to be dismissed, and that was set aside by this honorable court in Dharwad. That was set aside, and the matter was remitted back to the trial court to holding that it is not a trust, it is a society. Then, my
suit is
lord,
maintainable.
but
So suit is maintainable.
so by holding that it is not maintainable, and insofar as cause of action is concerned, there is no finding as such, perhaps in the second round of litigation. Only in the first round of litigation, there was a finding regarding cause of action. And thereafter, they have preferred that suit came to be transferred to the senior civil judge. Since my lords, it is a society, they claim to be society, it was transferred to the senior civil judge. And there, my lord, there now, in their 2015, the present suit, not we have filed an application. So, my lord, asking for rejection of the claim. That came to be, my lord, rejected by the trial court now.
Let's see that order. Page number.
Now, page number, it starts from page number 70.
Read from the reasoning part.
Please. Reasoning, my lord, para 10. The relevant observations will be, my lord.
So we'll understand
Marital
what it is. Let's
Please.
read from para 10.
It is a suit for declaration to declare that the plaintiffs are the absolute owners of the suit land and directing the defendants to deliver the vacant possession of the suit lands to the plaintiffs in the course of proceedings. The defendant number 12 was filed the present application seeking to reject the plaint on the ground there is no cause of action to file the suit, and various grounds urged in his affidavit annexed to the interlocutory application. The learned counsel for the plaintiffs has relied upon the judgment reported in so and so. Go through the ratio of the said judgment. The Honorable Appeals Court clearly has that the plaint must be rejected only if the averment therein explicitly disclose that the suit is barred by provisions of law, but not otherwise. Further, as the judgment of the Honorable Appeals Court reported in so and so, that at the stage of deciding application under section under 7, rule 11, only averments and allegations in claim are to be considered and not written statement or reply to the application or defense. So far as the above proposition of law of the Honorable Appeals Court in these two judgments is clear that to decide the application filed under Article 7, Rule 11 of CPC, the court must see only averments made in the claim and it cannot be taken into consideration the defense of the defendant and documents on hand. Accordingly, before going to discuss on interlocutory application, it is necessary to discuss about averments in the claim. The three formats of the claim are as under. According to the plaintiff, they have formed a public trust known as Sri Achyutashram Urupapara Gandhi. The same was registered under the Karnataka Society Registration Act 1960. Now, they have filed this suit as a representative capacity. In order to carry out the religious and charitable aims and objects of late Dr. Achyut Verma, who had formed an ashram by name Rushya Munkashram at Urupapara. Now, they intended to carry out the religious and charitable aims and objections of the said duty, Dr. B. Achyut Verma. They have formed this society. They submit that in the year 1949, the said UT, Dr. B. Achyut Verma, was acquired the suit lands in his name and formed this ashram. The said UT, Dr. B. Achyut Verma, was a great saint and throughout his life he was striving for social and religious development of mankind in particular, and he has lot of devotees. He was personally cultivating the suit lands and he had innumerable devotees all around, irrespective of caste and creed, and he has no relative and heirs to succeed to the suit properties. The said yogi, B. Achyut Verma, was died and cast his mortal body on 4th February 1958, and the same is enshrined in the Holy Samadhi erected in one of the suit land, like survey number 41 of the property. They submit that one Sri Karturi Kondargaon, son of so and Kadiyala Basaya, who are the residents of Lupaper Gatti, are the devotees, and they were close to late Dr. B. Achyut Verma. These two people were looking affairs of the ashram and supervising the agricultural operations of the suit land. Now, demand of the said UP, Dr. B. Achyut Verma, the new devotees were left the ashram, and no one supervising and cultivating the suit land at that time. Taking this opportunity, these two people who are Karturi, Kondasava and Kadiyala, Vasaya had a plan of developing the suit land. As such, that in collusion with the revenue officials, manipulated the revenue records and created a city in the name of Yogi and got obtained the city in their names in the respect of the suit land. These two persons did not have any right over the suit land during the lifetime of the said Yogi. These two persons have created, created and transferred the suit property in their names, and now they are in illegal position for suit properties. Initially, they are in permissive position to suit property. The plaintiffs submit that sometime the devotees of said Yogi gathered and they intended to develop the place shrine where Samadhi of Yogi was erected in survey number 4, and the said devotees were purchased the portion of survey number 41 from one Srimati Tulsibai, wife of Dharmoji Rao. Thereafter, they came to know that illegal entries made by the defendants by way of sale and partition in respect of the suit land. Initially, these defendants are in permissive possession over the suit land, and now by way of making this illegal entries, they become illegal possessors of the suit land. They submit that many of the devotees were gathered together and held meetings.
Yes, I see.
Please. Now, the trial court, so instead of discussing or going in respect of this cause of action, and it has discussed on the merits.
According to why there is no cause of action? Why there is no cause of action?
Because the respondent, that is the plaintiff, it claims to the society.
In the RFA, the court has given permission because the court has observed that it's a society. You can file a suit under 90. Then they have 5 days. Then the court has returned it to submit it before the appropriate court. Now, whatever the cause of action that is there for them continues to be there, but for the fact that on that count, the court expressed in the earlier round of the litigation that a devotee cannot maintain. So, how can you say that there is no cause of action for them? Their cause of action remains to be the same, but if they were not suited for one reason. Now that they have, they have taken the recourse to that it is not even your case, that now they are not interested parties, nothing. You say there is no cause of action.
Yes, cause of action.
Their cause of action is that the properties belonging to that institution where you have fraudulently executed a sale deed, and that has to be set aside, and you should come back to the institution and to declare that the institution is the owner of the property.
No,
that's a cause of action.
It is not even their case that these properties were transferred and they are the owners of the.
No, they say so. We'll see that.
No, they say because purchased in the name of.
No, let's see from the plain.
In the year 1982.
Para number 9. Para number 9 of the plaintiff, page number 48.
Yes. That the meantime, by grace of blessings of Yogi, scattered devotees were persuaded to come together to strive for rendering service to the ashram and to propagate the teachings of late Yogi. Such scattered devotees coming together held meetings and thought of giving a legal entity for the continuance of social and religious activities of the ashram. So they formed a trust and got the same registered.
So according to them, they came to know in the year 1995. And from 1995,
they formed a trust that was in the Andhra Pradesh.
They say they don't know about this till 1995. That's their case, which has to be looked into by the court, whether they have the knowledge or other things. No, as far as this can't be a res judicata
And not only that, madam, because they claim Yogi died, admittedly Yogi died in their 1958. And these properties were his self-worked properties. And he has not created any ashram, and these properties were not
But
transferred during his life.
that can be decided by way of a trial, not in a petition under order 7 to.
No, because if somebody comes, stranger comes and forms a society and claims that
And the
these
court,
properties belong to us.
that's what is adjudication. Court just like that cannot throw them off.
Yes, for that reason, my lord, on the earlier section also, the court has said
Has not
there is
said
no
anything
cause of
on-
action.
No, it is with regard to the devotees.
Not only devotees, madam.
The cause of, according to the
No,
court,
no, no.
let's see
Earlier
that.
they claimed-
Where did the court say,
earlier
let's see
they
that?
claimed-
Let's see that.
Earlier, they
If that
claimed
is the
that-
case, why would the court say that you are a society, go before the court and,
No,
under section 19?
earlier the court has said, you are not the society. If you are devotees, go under
And
section 92.
Then no cause of action.
Then again,
Either-
the
either
court
to
has
the-
said-
No, either to the devotee or the society, the cause of action is one and the same. Why would the court give a liberty to them to go as a devotee before, under section 92?
Well, it's only an observation, and the court has said, if they claim to be, if they are so advised,
No.
then
So in that
if they are so
case-
advised,
No, no,
and
no.
that can't be made up, the court has relegated them or directed
No,
them.
no, no.
to approach
Then that
the
the court will decide now.
And that's what, my lord. First of all, they have not made out any cause of action to proceed with the matter. That is the main contention, and even from the day one in year 1995, it was affirmed by the Supreme Court also, the Supreme Court. And
Finding that they
insofar as
cannot maintain a suit is affirmed, not other things. They cannot maintain a suit is affirmed.
yes, my lord, they cannot maintain the suit since there was no cause of action to file a suit. That was the observation in the even in the earlier proceedings.
So
also.
ultimately, with this liberty that is granted, which you have not questioned, no, that has to be decided by the
No,
court.
liberty, your lordship may kindly permit. However, we observe that if the properties in question really belong to the trust, as claimed by the plaintiffs and other devotees, can approach the jurisdiction district court under section 92 CBC for appropriate relief. And that was also thereafter, the district court has passed an order.
Saying that you return the plaintiff and
No.
before the court.
District court has initially dismissed their suit, and then they have challenged in appeal in the second round of litigation before this honorable court. This honorable court has said it is not a trust, it is a society. Again, it came back to the original position, wherein at the earlier point of time in the year 1995.
No,
while
at
filing
least
the
at this point of time, let us put a quietness to that instead of again going from this court to that court and that court to this court. Let the court decide it on the merits of it.
First of all, Order 7 rule 11 application. They should show that there is a cause of action to file suit. And only on that ground, even on the earlier occasion, in OS number 101 of 95, we have filed an application claiming, stating that there was no cause of action to file the suit. And even then also they claimed that it is a society. That has happened finally. And that specific observation is there, madam.
Let us understand, it's a question, on a question of res judicata, you say that it is.
Not only on the question of res
If it
judicata,
is-
even otherwise,
No,
madam.
you are saying now that as per your submission that in earlier courts it has attained, in the earlier suits, so it has attained finality. All those issues now it's a matter of, if it is a question of res judicata will be decided.
Not only question of res judicata,
One-
madam,
one
even
thing-
otherwise. Even otherwise.
Let us, take it point by point. Number one, if you say that it is on that ground, that would be decided. It is not a question of fact and law, has to be decided, number one.
Yes.
Number two, you say that there is no cause of action. Even on that cause of action also, where looking at the averments of the claim, it makes out a cause of action for them. Their cause of action remains. If the court says that there is no cause of action for filing the suit for them, there couldn't have been a liberty to them to go as a society. Now, if there is no cause of action, either to a devotee or a society, there won't be any cause of action.
But my lord, your lordship may take the para. I mean, permitted to read once again, my lord, para 5 of this honorable court finding. In this
Page
case,
number.
there is no dispute that the property is originally
Page
belong
number,
to
page
UP.
number.
Page number 112.
One?
112.
Yes.
Please. In this case, there is no dispute that the property originally belongs to Yogi, who was the founder of the ashram. The plaintiffs are not claiming title to the properties by way of inheritance or as appointed successors to Yogi. Here, this court has observed that ashram, the plaintiffs are not claiming title to the properties by way of inheritance or appointed successors to the
Let's
Yogi.
go to the trial court orders. Trial court order in this case. In that where the appeal is filed before the High Court, what is the finding of the trial court?
Please.
Page number.
In the
First instance,
Please.
where against that this appeal is filed.
Please.
Even to look at
Yes,
it,
105.
even to look at it, now how this court is looking, that earlier court has held that there is no cause of action. Further, these papers should be there before the court.
No, madam.
It has to be
My-
there, is it not?
No.
You are submitting that, this is the finding. No, even the trial court should have an opportunity to look at it, that how in the earlier round of litigation this aspect was decided and how they cannot maintain the suit. That you cannot cull out from the plaintiff.
No, earlier round of litigation, my lord, but that has attained finality by filing the even before the Supreme Court.
Who will tell the court all this?
No, we have stated, my lord, in this.
So can the court
Since
repeat
my
what
lord-
you have stated?
No. Since, my lord, it has attained finality and it is.
If it is attained by finality, that order the trial court should see. Is it not?
First of all, and my lord, of 7 to 11, they have to make out the cause of action. Otherwise, my lord, they should be
They made
sent
out
out
the
of the court itself.
They
at the
made out a
beginning.
cause of action. They made out a cause of action. That so and so safely is executed fraudulently or some property you have taken and you have, as if your property, you have created some sale, which is the case. According to you, that particular on the very same thing, earlier they have filed a suit and that litigation has attained finality where a liberty is given. But however, according to you, that rejection of claim that there is no cause of action, that observation as attained finality is your case.
Yes.
With the same argument, they filed this suit. For that reason, no, they have not said so all this in the plaintiff. They have not said about all these aspects. That is your contention.
No.
For that, you have to place before the court this judgment and all.
They have said, no.
They said, but not in so many words as you are saying. For that, the court should have an opportunity of looking at the order.
Yes, what is
So,
part of record minutes in the real
whatever
proceedings?
is a legality or otherwise of it, everything can't be, pressure side at a threshold. Please come. Agreed with the orders passed in I number 7 under orders 7 to 11. I number 7 filed under orders 7 to 11. Dated 25th July 2023. The defendant is before this court. The plaintiffs have filed the suit seeking declaration. Seeking declaration of their title and for recovery of the possession. It is a case of the plaintiffs that late Dr. B. Achyut Verma was a great saint, and throughout his life he strived for social and religious development of mankind in particular, and that of his devotees in particular. He and his inmates of the ashram undertook manual labor on the suit lands and personally cultivating the same. And he has innumerable devotees all around, irrespective of caste and creed. He died on 4th February 1958. And, and during in his lifetime, there are two devotees, one pioneer K. Kondalrao, Katuri Kondalrao, and Kadiyala Basaya, who are both residents of Viruparur Gatti. They were close to him and reposed great faith on them.
Yes, may I request my lordship to kindly service the lordship prayer. What is like plain? Lordship plain. Suit is for declaration of title and recovery of possession. But whether they can even otherwise, whether they can be declared as owners of the property and the possession can be handed over to some strangers and some third persons whom claim that they are the society and they file a suit, and whether such a relief can be claimed by them. And even otherwise that one, even on that basis also. They cannot maintain the suit.
What did you write? And we're looking after the affairs of the ashram, apart from carrying on supervising the agriculture operation of the suit lands. After the demise of after the demise of Achyutavarma, the ashram remained unattended, and devotees left the ashram for a number of years, and there was no supervision. Taking advantage of this, the close devotees hatched a plan of gulping the suit lands. They got the suit lands legally entered in the records of rights by coming in collusion with the revenue authorities. Thereafter, the devotees, it is stated that the the they've all the devotees who has pattern come together for rendering service to the ashram and to propagate the teachings of late yogis. They formed a trust and got the same registered under the Karnataka Society's Registration Act. An office was mentioned at Virupapura Gatti, and they started functioning by forming bylaws, holding meetings at Virupapura Gatti, collecting facts and material in respect of the ashram and the property of the ashram. And they came to know that in the year 1995, the sales have taken place by those two persons without any manner of right and title. Then earlier they have filed a suit, OS number 101 of 95, seeking recovery of possession. Then the suit was dismissed that there was no cause of action for the said suit. And suit was dismissed. They preferred RFA number 536 of 98. And the court, by dismissing the appeal, observed that the plaintiff society, having contended at this trust, could file separate suit under Section 92 of CPC. And by judgment and decree dated 7/12/2000, against that they filed a SLP number 10289 of 2001, and the same came to be dismissed on 12/7/2001. Stated that the plaintiff trust, being the body entitled to recover the property belonging to this trust, even otherwise, the devotees and bhaktas of the late Guru are entitled to succeed to the property left by him so as to continue the religious and charitable works of the said yogi. Therefore, the suit is also filed apart from on behalf of the religious society as a representatives of innumerable devotees. And that's therefore sought for declaration. In that, an application is filed at Order 7 to 11, stating that there is no cause of action for the plaintiff to file the suit. It is filed the suit, and accordingly, they sought to reject the claim. The court, by order APO, had dismissed the application. While dismissing the application, the court observes that the government of the plain discloses that the plaintiffs were the devotees of Achyuta Ashrama gathered and formed a society to form and to continue the social and religious activities of the yogi. They formed the society in the year 1982 under the Karnataka Societies Act. The court observes that though the society is formed in the year 1982, the information with regard to the illegal the alienations came to their notice in the year 1995 as per Article 164 within 20 years from the date of the legal possession. They have to file the suit within 12 years. It is observed with the court that when the defendants are in permissive position of the suit land, as allegations in the plaintiff, at this stage, the court could not hold that the relief is barred. The plaintiffs are barred from seeking the relief of possession. These are all the facts which should be taken into consideration at the full-fledged trial. At this stage, the prayer that there is no proper cause of action to file the suit and the suit is hit by res judicata are not applicable to the facts on hand. And further, the defendants have not made out any grounds to reject the claim. Accordingly, the idea was dismissed ex pere. When counsel appearing for the petitioner submits that the plaintiffs in the earlier round of litigation, the court has given a finding that there is no cause of action for them to file the suit when they are not the owners of the property. Question of declaring them as the owners of the property would not arise. Further, in view of the earlier findings of the court that there is no cause of action, they cannot maintain this suit as the same is hit by res judicata. It is submitted that they say that they have formed the association in the year 1982. And the sales were of which year? Sales were of which year?
Sales.
The sale deeds or the so-called sale deeds are saying and they have filed they say that they formed in the year 1982 and they came to know about the transactions in the year 1995. Then counsel submits that even on that count also the same is hit by the law of limitation. Even on that count also they cannot maintain this. Next cut. Having got the counsel on either side, there is a material not involved. The whole dispute is that according to the plaintiffs, the property belongs to the suit scheduled property belongs to late Achyuta. What is the name? Belongs to late Yogi Dr. P. Achyuta Verma. And after his death, the plaintiff, the defendants who are the devotees have illegally acquired the land belonging to the ashram where the devotees used to cultivate the land. Earlier, when you filed a suit as a devotee, the court the suit came to be dismissed, that there is no cause of action, and further, as a devotee, he cannot maintain the suit. Then in the appeal, this court has said that as if they are the society, then they have to go before the civil court under section 92 of the CPC, and such a permission was given. Thereafter, the present suit came to be filed.
They
And
claim to be society,
uh,
section 92 doesn't.
uh,
They claim to be trust.
trust, then thereafter, when they filed the suit, the same was returned to the, and to
Returned.
file it before the, considering it as a society, they were, the complaint was returned to be presented before the appropriate court. Accordingly, the present suit is instituted. The petitioner has raised several grounds with regard to the jurisdiction, with regard to the cause of action, and how the complaint has been rejected on all these grounds, on the ground of limitation and res judicata, and the same were not considered by the court. I mean, not the counsel petitioner, for this entire material not at all. The rejection of the plea from the arguments of the counsel is on two counts. One is there is no cause of action. The other is, in the light of the earlier orders passed by the court, that there is no cause of action. Now they cannot maintain this suit. There is no material before the court to see what was the earlier findings by the court. For example, the court has to look at the judgments that ought to be filed, which are not filed along with the plaintiff. So that issue of res judicata, the court cannot decide by looking at the plain amendments alone, as it has become a question of fact and law. It has to be decided after a full-fledged trial. Then when it comes to the cause of action, as, as it appears from the plaintiff has made out a cause of action. According to them, the High Court has given them liberty to approach the appropriate forum for the relief they are seeking. Their cause of action has remained to be the same as it was in the earlier suit. Then counsel submits that in the earlier suit, the plaintiff rejected that there is no cause of action. That observation still remains to be there, and as such, the suit cannot be maintained. Even on that count also, the court has to look at the judgment that is passed by the earlier proceedings, and on that count also, the plaintiff cannot be rejected. That was the matter. This court finds no reasons to declare or dismiss.
Now the issues have been heard and the evidence is going on. The court finds there is a ground to consider some issue as preliminary, and the court can decide.
It is submitted that the issues are framed by the court, and if any of the issues that are framed can be decided as per the as a preliminary issue, as per the procedure, the court can decide the same as a preliminary issue. As no adverse order as no adverse order is passed against the respondent, the issuance this court does not issue any notice to them. Yes.
Since one of your last sir made an observation, after full-fledged, it can be come to a conclusion. So
Yes.
we cannot be deprived of that.
Yes. After lunch. Signatures? No signatures.
On submission.
No mentionings now. We'll see after lunch. Which one?
30.
What is this non-filing of affidavit? No, no, this the acknowledgement for having paid amount. Another?
So now we are in 2024 year launches. Totally 25 months are calculated. Each one 8,000.
How much?
2 lakhs.
Hmm.
2 lakhs. We have 1 lakh is paid. Another 1 lakh is reserved.
There's an interim order. Hmm. So when are you going to pay?
Now I have 30,000. The lady has paid.
No, once you pay, then we will hear.
He is here.
Who is here?
In fact, they have acknowledged the payment of 88,000 for the whole year and 40,000 is paid here on the last occasion.
Hmm.
And so one of the remaining ones somewhere around 80,000. What is the income to be paid? But then we are at 20% in the whole year. This is dated on 1/1/2/1. And in that one,
No, today I think is paying 30,000 to take that, and will list this matter on 11th. By the time the remaining amount shall be paid. Until such time they'll not pursue the recovery proceeding. It is submitted that earlier they have paid an amount of rupees 80,000. Next. For 80,000 and 40,000. Huh? That's right. 80,001 and before this court 40,000 they have paid, and today he is going to pay another 30,000. It is submitted that by 12th the entire arrears will be cleared. Then counsel appearing for the respondent submits that what she has received is not 80,000, but it is 60,000. But it is 60,000 before the trial court. Today before this court given him. No, no, not about that. We are not on that. About the money. The party has given an amount of rupees 30,000 to the wife. It is submitted that by the counsel for the petition that the respondents are going ahead with the recovery proceedings, considering the submissions. The court is passing the following order by the next date of hearing, that is 12th of December. The husband shall clear the entire areas. Till such time, the wife shall not take any coercive steps. Public shall not pursue the recovery proceedings. Is this on 12th, huh? You can't file it here. But by 12th, the registry is that to call for the TCR. Yes, next. Post along with that on 11th. Yes, next. Huh? That's fine.
This is husband's petition, yes. The wife seems to have filed one more petition that is connected along with this matter. Notice is not issued in this matter.
32.1. The ICS submits that they have she has instructions to appear in this matter. in the name of so and so, counsel for the petitioner shall serve the copy on the counsel appearing for the respondents. Yes, this is matter on.
One more submission, Millards. Millards, in this matter, as in arrears, Millards, we have already paid around 20 lakhs to the respondents here in Millards. Now, Millards, the petitioner hearing is ready for payment of a permanent element, Millards. Let them come with some proposal.
It is submitted that the husband is ready for a one-time settlement.
Please, Millards.
That counsel for the respondent shall get specific instructions in this regard and convey the same to the counsel for the husband.
Please, Millards.
Yes, next. Yes. Amount is paid, amount is deposited by the petitioner. No representation for the petitioner. This court has granted order on 24/4/2024. The stay is granted on payment of, subject to condition of paying the maintenance. The land counsel for the respondent is at liberty to withdraw the same. List this matter after winter vacation. Yes, 35.
Husband has filed this petition.
Yes.
Husband has filed this petition.
Yes.
Maintenance of book is 5,000 to the petition number 1. Wife and 3,000 each to the child.
11,000 is granted. What is your income?
20,000, 20 to 21,000 the salary set to be.
What do you do?
21,000 minus.
What you do?
Private work. In private company, he is doing private job. He is ready to pay the maintenance, but a little bit reduced, then he is ready to pay the maintenance also. And he is the only son, he is having his parents also. The recovery petition has been filed by Mr. and he has paying the arrears of maintenance in the before family court management.
Yes, what is? Yes, he is talking about a salary certificate. It was not filed before the court, salary certificate.
What is management?
It says you have not filed the assistant liabilities, you have not filed.
Assistant liabilities are not filed before.
Why you have not filed? Both the parties are directed to file their respective statement of assistant liability as per the judgment of the apex court and the attorney of Sneha. This is matter after winter vacation. Yes. Next.
CRP has been filed challenging the civil misdemeanors order. Civil misdemeanors was filed for the transfer of restitution. See the transfer of OS 161.
What is this connected matter WPA?
WPA is challenging the order passed by the subsequent suit members, that is staying of the subsequent suit. Plus the fact that the respondent herein had filed a suit for declaration in the year 2019, speaking that she is the only daughter of one mom. Thereafter, I contested and I filed my written statements. And thereafter, I filed one more suit matter in the year 2021 for declaration and injunction, saying that I am the legal wedded wife of Babu Reddy and my daughter is the legal heir of.
So, you being a party to that suit, you filed a separate suit.
Yes, sir. But beliefs order is different.
What is it about? She also sought declaration that so and so, she is the daughter of so and so person. You are the wife of so and so person. Then you could have filed the same counterclaim in the same suit.
Yes, but instead I preferred a suit. But my lords, the outcome of the suit will be different. My lords. Suppose if she succeeds in her suit, I'll be put into the loss, my lords, because
So you want her suit to be stayed?
no, my lords. I have had civil misdemeanors to come back, to transfer and club my suit with her suit, so that it can be worked together.
When is her suit? Which year is her suit?
21.
Which year is your suit?
Well, it's her suit is in the year 2019. And my suit is
And what were you doing from 2019 to 2021?
I've contested my lords, I had filed written statement in court.
So what the court did is, now the court has refused to club, number one. Number two, court has refused to stay the proceedings in her suit or your suit.
No, my lords. She had filed an allegation for stealing of my suit. And that has been, my suit has been stayed.
That's it.
I preferred a civil misdemeanor.
Both are right orders.
No, lords, but one submission, my lords. Civil misdemeanors has been discussed only on the ground that I had not challenged the order passed in regarding the stay, my lords. Thereafter, now I preferred WP.
Now, in the light of your suit being stayed, no transfer is required.
Yes, but the consequences will be.
You are contesting the suit, you keep quiet for 2 years, suddenly you realize and file some other suit, which you could have the same relief in this.
My lords, but the outcome will be different, my lords. Even if she succeeds, it will affect my suit, my lords, because
Let her, you are contesting the suit, let it happen. Please come.
it can be clubbed, my lords, because same party can choose.
No, it is safe. No, you don't have to worry about the conflicting of judgments because unless and until her suit is decided, your suit will not be.
Yes, my lords, but if she succeeds, even after if her suit gets dismissed, my lords, again I have to prove my case, my lords. There will be coexistence with this passport.
What is the stage of your suit?
Plaintiff side evidence, my lords, it has already been closed, my lords. Now the court has posted for the defendant side evidence, my lords. Due to the pendency of this petition, my lords, they have asked time for the defendant side evidence, my lords.
What about that suit?
That should have stayed, my lords.
No. What was the stage before stay?
Just they have not filed any
Notices are also not
No,
completed.
no, my
Service of
lords.
notice.
No, my lords.
She had not filed the written statement.
The in CRP number 1000107 of 2024. Where is the order? Page number?
Page 26.
Page?
26.
It's 26 minutes. Okay.
Page 26. I'm looking at the CRP.
Hmm. 89.
Hmm?
89. And next to it, page 89.
The present revision is filed. Agreed with the orders passed in I number 1 in OS number 169 of 2021, dated 23rd September 2022. No, I think there is something wrong. Writ petition is filed against which order?
Because writ petition has been filed challenging the order of in writ petition page 26, challenging the order of stay of subsequent.
That is what you people are showing me now as an influent order.
No, in CRP it's page number 18.
say, very same order, what is there you are referring in the writ petition, what you are referring in CRP is the very same order. Where is that second order where your request for clubbing of the cases is dismissed?
Sorry, page 97.
Page number?
97.
I believe the order is passed in civil miscellaneous number 5063 of 2020, dated 22nd January 2024. The petitioner is before this court. The petitioners herein have filed a suit, that's voice number 169 of 2021, seeking declaration and consequential relief of injunction with regard to the suit properties. What is the suit? Let's see that there is a claim. Voice number 169 of 2021.
Page 66.
Filed a suit. What is recorded by the court as nothing. Voice number 169 of 2021 is filed seeking a declaration that the plaintiff number 1 is wife and plaintiff number 2 is the daughter of one Babu Reddy, Venkat Reddy Tungal, and also a consequential relief for injunction is sought. The respondent herein has filed voice number 114 of 2019 on the file of the additional civil judge at JMFC, Jamkandi, seeking, where is that claim? Seeking a relief that a declaration that the plaintiff is the legally wedded wife of that person, Babu Reddy. Seeking a declaration that she is the wife of Babu Reddy, Venkat Reddy Tungal. In the suit, that is voice number 114 of 2019, the present petitioner is arrayed as defendant number?
Defendant number 1.
Is arrayed as defendant number 1. The petitioner herein as a defendant has been contesting the said suit and thereafter had filed the present suit. And now this application is filed seeking to withdraw the suit in voice number 169 of 2021, pending on the file of the principal judge JMFC Jamkandi and transfer the claim to the Court of Additional Civil Judge at JMFC, before whom the suit voice number 114 of 2019 is pending. The same is dismissed by the court on the ground that when OS number 169 of 2021, orders were passed on IA number 1 under 10 of CPC on 23/9/2022, wherein the proceedings in voice number 169 of 2029 1 has been stayed till disposal of voice number 114 of 2009. The court observes that against that order, no appeal has been preferred and it has reached finality. When all the proceedings in voice number 169 of 2021 has been stayed till disposal of OS number 114 of 2009 under section 10 of CPC, then there would not arise any conflicting or multiple orders concerning the same subject matter, and therefore no effective purpose would be served in transferring the suit to one court for clubbing and disposing together. The contention raised by the petitioners in voice number 169 of 2021 is already in defense set up in OS number 114 of 2019 by way of written statement. Therefore, the court has not court felt that there are no reasons and accordingly dismissed. Agreed thereby, the CRP is filed. The order where the suit was stayed, that is IN number 1 in OS number 169 of 2021, dated 23/9/2022, WB number 106913 of 2024 is filed. It's a common order. Hence this court is passing a common order in respect of both the CRP and the writ petition. The whole dispute is in the first suit, that is OS number 114 of 2019, the plaintiff seeks a declaration that she is the wife and the other plaintiff is the daughter of one Babu Reddy Venkata. She is the So in the first suit, the plaintiff seeks a declaration that she is the daughter of Babu Reddy Venkata, whereas in the subsequent suit, the plaintiffs want to seek a declaration that the first plaintiff is wife and the second plaintiff is the daughter of Babu Reddy Venkat Reddy Tungal. The first suit of 2019, where the plaintiff's evidence is closed and it's coming up for the defendant's evidence. Whereas in the second suit, now only the notices are served. The application that is filed by the plaintiff in the first suit, that the proceedings have to be application filed by her under section 10, seeking stay of all further proceedings till the first suit is decided, was already ordered by the court. That order is in the year 23/9/2022. That is, that order is dated 23/9/2022. Against the said order, after 2 years, almost 2 years, the writ petition is filed before this court. When the dispute between the parties is, the dispute between the parties is with regard to their status and their relation with whether they are seeking a declaration that whether they are the daughter and the wife of Babu Reddy Venkata. The petitioner here, who is the plaintiff in the subsequent suit, had kept quiet for 2 years by contesting the said suit and now files a second suit. As the first suit has come to the stage where now it is ripe for hearing. Now at this stage, again, that suit cannot be, the subsequent suit cannot be clubbed with the suit. Further, as already the court had rightly stayed the further proceedings in the later suit. At this point of time, clubbing both the suits would not arise, and it is not in the interest of the parties as well as the speedy disposal of the case. In that view of the matter, this court is of the considered opinion that both the orders passed by the trial court dated so and so are well considered orders and needs no interference from this court. Accordingly, both the CRP as well as a repetition or dismissal. Yes, next. Yes.
Petitioner mode suspend petition. 12,000 amount has been granted. Include audited page number 24.
How much is granted?
12,000.
What is your income?
I am doing tailoring work, first point. And second point, my lord, sir, both of them are staying separately lasting 28 years. And my age is right now 62, my lords.
Children?
No, my lords. And she has got married another person also. My lords.
Then now is she entitled?
The petitioner.
It is there on record that she is married. When is she married?
The petitioner.
Huh?
The petitioner married for second year.
You mean to say petitioner got married?
Yes, my lords. No. Respondent, she has also got married to the second wife, my lords.
Where is that? From where you are saying that the wife has remarried? Where is that?
I have the it is in Urdu.
The respondent shall file an affidavit. It is counts for the petitioner submits that she is already married. She has contacted the second marriage and she is not entitled for maintenance. Then counts for the respondent submits denies the same. An affidavit shall be filed before this court by the respondent whether she remarried or not. This is matter on 19, not 19, on 13. Yes, next.
Please.
Yes.
Yes, they have not complied the order, madam.
What is the order?
That order.
One submission on the last occasion, Lordship has permitted us to remove the
encroachment.
My Lord, since yesterday, my Lord, steps have been taken by the.
Show it to him.
Yes, annually, steps have been taken.
We'll post it tomorrow so that you can also get instructions.
Since manually they are doing, my Lord, it requires a dump.
When they do it, madam, I must well submit.
No, that's why.
Yes.
Whatever they are submitting, you can also get instructions. We'll list this matter tomorrow.
Tomorrow will do it. Tomorrow I.
You don't have to be here
Yes.
for the instructions. Your colleague can be there.
Yes, ma'am.
Yes.
Please, please.
It is submitted with the land council petitioner that as per the submission made before this court, they are already clearing the encroachment.
Yes.
Land council for the respondent submits that you'll get instructions in this regard. This is matter tomorrow.
Please.
Yes, next. Yes.
Husband has paid 6,000 rupees maintenance has been awarded. After filing the maintenance petition by the wife, the husband also filed refusal to do right to my lordship. And the same was dismissed and it was also challenged before this High Court and MF is pending, my lordship. And moreover, my lordship, she has admitted that only 5 months she has resided with the husband, my lordship. And both have came to the Hubli for taking treatment. And there is no proof regarding the harassment or negligence, my lordship.
Now your restitution is dismissed, so we cannot, you don't have to argue on that. Now you have to argue on how this 6,000 rupees is on the higher side.
My lordship,
Our entitlement now you cannot question in the light of your restitution petition being dismissed.
Lordship, the husband is doing a coolie work, my lordship. He is a painter. He is doing in a village, my lordship, and he is having 4,000 to 5,000 in monthly income, my lordship. And moreover, he never neglected to her, my lordship. Till date, he is ready to take her back, my lordship. Even he is ready to make house at Hubli itself, my lordship. Hubli,
He says that his monthly income is 4 to 5,000.
No, before that, now the restitution is dismissed. You want to join him?
No.
But in that case, then you should have, you must have contested.
We have contested the matter before the trial court.
That means you want to join him.
No, my lord. Also, and 6,000 is quite a bit meager, my lord. Instead, I should have filed a petition for seeking enhancement of the.
It's like two things. Either you want to join him, or if you don't want to join him, you should have a divorce.
Yes, madam. My client is not ready to join this company, madam, because there's lots of harassment being given to him. She was carrying, madam, due to the harassment given by him. She has even undergone an abortion due to miscarriage as well, madam. And now they say that
What is the evidence before the court? Let's see.
there is a medical report given, madam.
Not about that. Evidence about the income.
Income he has not furnished assets and liabilities before the trial court, madam. Here he has submitted before this honorable court.
What is that? When did he file?
On 6th of August 2024, madam.
6th of?
6th of August, madam.
Yes. What he says?
Well, he says his general monthly expenses are around 4 to 5,000. And then he says that approximate expenses that are incurred by him to maintain his parents is around 6,000. And his income is around 4 to 5,000. His expenses are exceeding his income. How can that be even possible? And he even has agricultural lands.
His father and his elder brother is there, my lordship. Both are going to look after his father and mother. Yes, they are both are aged, my lord.
We are only talking and we are only speaking about what you said. You don't tell about the entire world what they are doing. You will only tell about what is that you are spending.
Please, my lord.
So you say you are spending 10,000. Where from you are getting?
Sir.
So anyway, you are spend it for the wife and
My
daughter.
regularly, he will not get the work, my lordship. Sometimes he will get more work, sometimes he will get lesser work, my lordship. On contract basis, they will get the work, my lordship. Because of the contractor, sometimes when the contract will get, then that time they will give the work to the respondent, my lordship.
And also, madam, he's not a labor, as in painter, as in he's not a labor, madam. He is himself a painting contractor, and he's even involved in some gully bag businesses and all of that. And apart from that, he has even agricultural income, madam.
My lordship, the entire petition, my lordship, the negligence, there is not at all proved, my lordship. And why he never neglected to his wife, my lordship. And there is no complaint filed against him with respect to the cruelty caused by the husband, my lordship. Till date, there is no complaint filed against him, my lordship. And he is very much interested to take back her, my lordship. Even the wife is residing in Hubli, he is residing at Hangal village, my lordship. And he is ready to make house here, Hubli also, my lordship. Even in short of that,
She doesn't want to come. How can you compel her?
No mistake has been committed by the husband, my lordship. In spite of that, he is facing problem, my lordship.
Agreed with orders, Carson. Criminal miscellaneous number 341 of 2023, dated 24th April 2024. The husband is before this court. The respondent wife has filed a petition under 120 CRPC seeking maintenance of an amount of rupees 30,000 per month. It is a case that in view of the harassment by the husband, she is staying at a matrimonial home. She also filed a petition under the provisions of the Domestic Violence Act. It is a case that husband is getting more than 30 to 35,000 per month, and he has failed to provide the maintenance and completely neglected the petitioner. The family court, by order impugned, had granted maintenance of an amount of rupees 6,000 to the wife. The court observes that, as it could be seen from the records already, court has granted interim maintenance of rupees 3,000 per month in favor of the wife. But after appreciation of the oral and documentary evidence, the court is inclined to grant rupees 6,000, which would reach both the ends of justice. The court also observes that the husband is a healthy and able-bodied man. On the other hand, the wife has been suffering from health issues And obviously she is not in a position to do any work. The husband, who is having sufficient income, is capable of taking care of the wife, but he neglected her. Accordingly, the said amount is granted. Let counsel appearing for the petitioner, husband submits that the wife without a reasonable cause is staying away from the matrimonial home. Even today he is ready to take her back and take the responsibility. He submits that he is working as a coolie, is doing the painting work, and he'll be earning the daily wages between 3 to 400. He has old age parents whom he has to take care, and old age parents to take care, and his income is around 4 to 5,000. It is submitted that in the court without any evidence with regard to the income of the husband had granted 6,000, which is on the higher side. He further submits that the wife who is staying away from the matrimonial home without a reasonable cause is not entitled for any maintenance under 125 CRPC. Next paragraph. Then counsel appearing for the respondent, respondent wife submits that the husband has filed a petition seeking restitution of conjugal rights that came to be dismissed, and against that MFA is filed before this court, and the same is pending consideration, which clearly shows that there is a reasonable cause for the wife to stay away from the matrimonial home. She submits that the husband is working as is taking up a painting contracts and is having any sufficient income. It is further submitted that as per the order passed by this court, the husband had filed before this court the statement of assets and liabilities, wherein he shows that his monthly expenditure is between 4 to 5,000, and he is paying an amount of ₹6,000 towards the expenditure of his dependents. It is submitted that looking at the statement of assets and liabilities that are filed before this court shows that the petitioner has come before this court with all submission and misrepresentation of facts. Having got the counsel on either side for the submission on record. The counsel for the petitioner had argued more in the without a reasonable cause, the wife is staying away from the matrimonial home. In the light of the dismissal of his petition seeking restitution of conjugal rights, it can be this court is not inclined to go into that aspect, and the court had rightly considered that the wife is entitled for maintenance. Coming to the quantum of maintenance also, and as rightly pointed out within accounts for the respondent, with regard to the discrepancy in the statement of assets and liabilities, also strengthens the case of the wife with regard to the financial capabilities of the husband. Even on that count also, this court is not inclined to interfere. Accordingly, next. Where is the petitioner? Let's see. Go the file. Seeking transfer from where to where?
That's Koppal to Dharwad,
Distance?
163 kilometers.
Why it shouldn't be transferred? I know.
Their submission is Malad. 2 years child is there.
Not for them. I'm saying how it should.
But my submission, Malad, the father of the respondent is suffering from paralysis.
Father of the respondent.
Respondent is suffering from paralysis, and also the distance between Koppal to Dharwad, which is almost 160 kilometers. In the middle of the mercy, it may be transferred. It is convenient to the both parties. May be transferred together.
You will even if your father is suffering from paralysis also, no, what will happen is again she has to travel. If it is 60 kilometers also along with you're traveling, so travel little more. The present petition is filed seeking transfer of MC number 84 of 2024 pending on the file of the Principal Judge Family Court couple to Principal Judge Family Court Dharwad. It's the facts of the case or that the marriage is solemnized between the parties on 25/6/2020 and they are blessed with a male child on 14/9/2022. In view of the differences between the parties, the husband has filed a MC seeking divorce, that's MC number 84 of 2024, before the Principal Judge Family Court at Koppal. It is a case of the wife that that her child is around 1.5 years old, and the distance between both the places is more than 180 kilometers, and it's very difficult for the wife to travel all the way. Hence, she sought for transfer. Next parallel, and counsel appearing for the respondent submits that the wife submits that his father, the respondent's father, is suffering with paralysis, and it's difficult for him also to travel 180 kilometers. He submits that the matter may be transferred to a place where it would be convenient for both the parties. Next paragraph. However, the counsels on either side, there is a material not recorded. The distance between both the places is about 180 kilometers. The wife has has a daughter who is 1.5 years old to take care of. Now, if it is transferred to an in-between place, still the wife has to travel, and she has to take care of the child. Considering all that, this court deems it appropriate to pass the following order accordingly. So and so is allowed by withdrawing so and so and transfer to so and so accordingly allowed. Yes, next.
Petition of seeking transfer of the matrimonial case from Hungur
Trial
to-
court proceedings.
It is filed at Anicha minutes. Page number 16.
Page number
16 minutes.
Ah.
It is at the evidence stage minutes.
It can't be transferred. Please come.
Husband himself is staying at Bangalore minutes. And I have filed
It is not about you and husband now. It's about the court.
I have a minor child minutes.
What were you doing till the evidence starts? The present petition is filed, seeking transfer of MC number 27 of 2022, pending on the file of the senior civil judge and JMFC. What is that? Horgon to the principal judge, family court, Bagalkot. It is stated that the facts of the case are that the marriage was organized on 24/5/2019. In view of the differences between the parties, the respondent has filed MC number 18 for MC number 27 of 2022, seeking divorce, and the wife had filed restitution of conjugal rights. That is, what is the number?
No, it's 118 of 2020.
118 of 2023 on the file of the principal judge, family court. Which family court?
Bagalkot.
Family court, Bagalkot. It is submitted that the distance between both the places
Around 50 kilometers.
around 50 kilometers, and it's difficult for her to travel. As such, the petition may be transferred. Next one. Having heard the grounds for the petition, this court has published the evidence on record. The proceedings of the family court shows that already the evidence has commenced. And the MC is of the year 2022. The petitioner has come to this court in the year 2024. It is also stated that the wife husband is not staying in Bagalkot, he is staying in Bangalore. Now, when once the court has heard the parties and the matter has come to has reached the stage of evidence, at this stage, for the convenience of the parties, the petition cannot be transferred accordingly. Dismissed. Next.
They have an alternative remedy under section 61 subclass 2.
Appellate authority.
Please.
No, that apart, what are your instructions? Instructions, not on legal, factual.
Actually, we have given this license, renewed this license.
Why are you renewing the license like this?
With a condition, ma'am. With
What condition? Condition is
For the getting revenue to the state, we have granted them many licenses.
5
And,
years.
and also renewed.
5 years.
Please.
How can it be?
No, not 5 years. For every year we are renewing.
From how many years you are doing it subject to?
From 21, we have directly issued them a notice to submit that
No.
record.
Till what time you are having the star hood, that, what is that,
2020.
2000?
20.
20, from 2020 you are not having. So 2021, 21, 22, 22, 23, is it not, it's some
20.
kind of,
No, every year at the time, every year at the time of renewal, they are filing the affidavit saying that we will produce it. Every year they are doing that step.
is it like,
And in
no,
this
no, no,
20,
you are,
24,
no,
25.
no, please don't tell that. Your officers are so named that they don't even understand that very innocently what they are telling you are doing it.
Due to revenue only they
What
have-
revenue? Then no also give.
No, that's why from 21 we are reminding them and we are issuing the notice them. And this year, at
And
the time of granting a license,
happily, a person who is not having a star hotel status will enjoy a 6-year license, and you happily take it and you will keep quiet.
no, for that only this year.
No, there should be some, there should be some transparency in what you are doing.
Right.
All different yardsticks, whatever you want to do. Who appeals for the central government, for the tourism department? What are your instructions? Huh? Why? Why are they not giving you instructions? No, this is such an unfortunate case, Mr.
Please,
Government Advocate.
please.
Where is your AAG? Ask him to come. Call him.
Please.
Short password. Yes, next matter. Yes.
Insofar as WS contentions are concerned,
Not WS contentions. The court simple. It is settled law for deciding an application order 7 to 11. We don't have to look at any other thing. Only the plaint and any other document that are filed along with it.
Yes.
What I'm saying is, if they filed a plaint, you filed your written statement. Basing on the pleadings, court has already framed the issues.
yes,
Now suddenly you come up with something. At this stage, can you come up with an order 7 to 11? For that you said at any stage it can be done. Yes. At any stage, contrary to your pleadings.
that is not there.
That's the important point.
That is not when.
I'll tell you now, for example, there are 101 legal propositions that are available that you don't take. If you don't take, court will not decide. Is it not?
Certainly not.
Court will not decide.
Certainly.
No, that's the whole purpose of taking the pleadings. Basically, no, this order 7 to 11, what is the purport of it? To see that a full-fledged trial is not there and a frivolous litigation that can be curbed at the nip. That's the whole purpose of order 7 to 11. In this case, written statement will be filed, issues will be framed, and after that you come up, what is the purpose of a petition of this nature? That is, no, order 7 to 11 is like whatever the latches in the pleadings are there. No, by virtue of this, you will be doing
That
it.
is not the.
No, even if such a, if that is there, you are open to take up all those contentions before the trial.
That is not the case. But see, at any point, even my lords, even after filing of, immediately after filing of, framing of the issues, I have filed this application. It is not that, my lords, I waited for long till completion of the evidence and other things. I have not waited till that time.
immediately after noticing this, after within 1 month, issues were framed. In the month of February, and in the month of March, immediately I filed this application. I have not waited for a long time.
Let's see, what is this order you are relying on?
In this case, paragraph number 9. A perusal of order 7 rule 11 CPC makes it clear that relevant facts which needed to be looked into for deciding an application
This
there.
is a settled question.
In this case,
Yes.
even stage of the at any stage, it can be filed before completion of the trial.
What is that? What is that stage? The trial court can exercise the power. Read.
Please, Manoj. The trial court can exercise the power under order 7 rule 11 at any stage of the suit before registering the suit or after issuing summons to the defendant at any time before conclusion of the trial for the purpose of deciding application under clause 8 and D of the rule 11 of order 7 CPC. The averment of the plaint are germane and the pleas taken by the defendant in the written statement would be only irrelevant that stage. Therefore, a direction to file written statement without deciding application under order 7 rule 11 cannot be but be procedural irregularity touching upon the exercise of jurisdiction by the trial court.
Yes.
Right. And one more submission my learned friend made after reconstitution of states we are in Karnataka.
That I am not going into that aspect.
Yes.
Anything you want to add?
Please, ma'am. After the issue are framed, trial has been done. Plaintiff has adduced evidence and crossed. He has crossed, and thereafter DW1.
At that stage, this application is filed.
No, madam. After issuance of issue are framed, thereafter only I has been filed, and in 2021, madam, he adduced the evidence, madam, DW1, madam. In that also, madam, he has not assigned any pleading, madam. This aspect, madam.
Yes. Third result.
One more submission.
Yes.
One submission which I wanted to make. My learned friend made a submission that Bombay School of Hindu Law is not applicable to him. I mean, to the case. If that is the case, plaintiff number 2, my lord, is wife of defendant number 1. Under which provision of law she is claiming partition in this case? Because except in Bombay School of Hindu Law, wife will not get the share in the partition. If partition is being taken place, then she will get that of a equal share to the equal of the son only in Bombay School. And in this regard, I am relying upon, insofar as Bombay School is concerned, I am relying upon this data. Share of the wife is concerned, and insofar as Article 306 of the Mullah Hindu.
Yes, that also. Right, petition.
Please.
Yes, next. Yes, that password matter. What is this happening? From 2028, you will keep on giving him that subject to. What is the subject to? Huh?
It can't be done.
But has been happening. It has been happening and he's enjoying. Suddenly you are disturbing him with all these notices. Because anyhow you were in deep sleep. Let it continue for some more years so that they will. The tourism department will also sleep.
It can't be done.
They will enjoy.
It can't be done like this. Only at the time, this will be on the every time of renewal. They should see that if they have all the required document. Then only if they have required document, then 6A should
That
be
too,
issued.
particularly, the 6A can only be given to a star hotel.
Yes, it's only.
It cannot be given.
Critical nobody.
When that is the condition precedent for grant of license, where is that subject? Where is that subject to obtaining? First of all, you renew and say subject.
My respectful submission is that the renewal itself, if they don't have a certificate, they are not entitled for the renewal.
But you have been doing it. Who are doing it? So what are the affairs that are going on? That is a sorry state of affairs. Yes.
Now that because they have renewed it from July 2024 to 25.
Who renewed?
The state board, the excise department. That license is
But your tourism department has not given you the status.
not because you have uploaded our applications.
No, please understand, it's not about
Yes, madam.
uploading the applications. Now, for getting the license on the 6A, the condition you should have, whether your application is pending before the tourism department, whatever that happens between you and the tourism department is not a concern at all to the excise department.
One of two of the cases it was there earlier and renewal is pending out of these hotels. And one more thing is that not even if the lawsuit used to follow this guidelines of the tourism department for issuance of this certificate of category. There is some time frame is also there for them, which they are not compliant.
But you also have not asked it. When you are not doing, they are not doing it from 2020. You are happily getting your renewal and you are happily keeping quiet. No, the court will not come to the rescue. They will dismiss all the petitions. As far as the other prayer is concerned, you should go.
Other prayer is there.
That the prayer with let them come. For that, these people can't, because excise department is nothing to do with your what happens between you and the tourism department. That is independent entity completely.
Their submission is now that they have renewed it for 1 year and half.
Why should they do it? That is an illegality.
They have even collected the revenue also for the
They
entire
will.
year.
You were enjoying that from 20 to 23 without any right. So in fact, they should initiate proceedings for recovery of that.
Only my request is let them extend it for 3 months. They withhold that notice, and then in the meanwhile we will get it. Our applications are in process, and let them
Eternally in process.
No, we have even this court has directed issued the notice also now.
It is just a notice that what they will do. No, because notice is given, that doesn't mean that. First of all, this you should ask your deputy commissioner what is he doing.
But admittedly, very renewal itself is bad in law. It cannot be. They are not entitled for renewal. There is no, because of some department they are not given. It doesn't mean that they are entitled for the benefit of non-getting.
Action should be taken against the officer who has done it.
That I am not. Yes. Very condition system for 6A is that it should be started.
No, first of all, like this.
Yes, no,
you do it, you don't follow the procedure, you do something. Later you start recovery. Why should you do this and why should you do that next? Now you will start the next step that they are not entitled and they have been enjoying it. And you are sleeping. Your department is completely in a intoxicated state.
The very fact that renewal is sufficient, nothing more than that. If they don't have a certificate, there is no question of issuing certificate, whatever reason may be.
Yes. Well, dismiss. As far as that, we will not give them any direction to do anything. Let your second relief with regard to the tourism department. In fact, you should file 2 writ petitions for this. They are entirely 2 different departments, unconnected. This should have been for this, and that should have been for the other relief.
Not unconnected, not they are interconnected because they say that to issue this thing, my bar license is there. For bar in category 4 and 5 category, bar license is also mandatory to get the category.
They will not. Well, I'll make it clear that as far as your first relief is concerned, this court is not interfering and you are not entitled for any relief for these reasons. And as far as the relief number 2 is concerned, let them come up with their objections. Because you can't maintain this petition, and the court, particularly whatever the understanding between you and the respondents, it's happening. Now, court will not be a party to this, and court cannot look at it in that manner. And if the court is not reacting to it, then court is also acknowledging that what they are saying is right. Give that. Give the. That will be number 1067.
The Lord's permission, if you recall, tomorrow, my lord, I seek instruction to.
Regarding the 5 and 6, my lord, they are not relevant party at all. The tourism license has to be issued by the central government.
Under the
You
6th,
represent central government.
it is 5 and 6th. The act itself is very much clear.
No. Who is the person now as far as the central government is concerned? You are from the central government. So you cannot say that I'm not getting instruction. If you are not getting instructions, who is the sixth respondent? Who is the sixth respondent?
Sixth respondent is the corporation, tourism corporation, Indian Tourism Development Corporation.
Represented by?
That is by the separate council, I think. Yes.
Corporations are represented by whom?
Wing of that department.
The instrumental is the
We ought to have made tourism department as a party.
You are not made.
We have not made tourism department, but the tourism corporation we have made. And state
But who will give you the status of the staff hotel?
Star Hotel status in coordination with tourism department of Karnataka state central government.
Where is central government party?
Which is respond number 4, right?
Indian Tourism Development Corporation by its managing director.
Respond number 4.
The regional director and convener, hotel and resort approval and classification committee and Ministry of Tourism, Government of India, Southern Region Office, Chennai.
Yes.
Who appears at 4?
Central government.
That's what, if you tell them, if they are not giving instructions, then we'll ask them to come to the court and tell the court. Because councils are there to, it's their duty to give instructions to the councils. If they're not giving, we have no option but to call them. Yes, we'll be posting this matter tomorrow. No, it will come tomorrow. Get a telephonic instruction. The land counsel for the petitioner as well as land counsel for the fourth respondent wants to get instructions. This is matter tomorrow. Already enough opportunity is given to the fourth respondent to get instructions. If the fourth respondent is not giving instructions,
Fourth and sixth.
Fourth and sixth are not giving instructions to their respective councils, they shall appear and submit the instructions. Yes, next. It will come tomorrow, please get instructions. Yes. Huh? No. Yes, for the next case. Huh? Anyway, your role is not here as of now. Yes.
Okay. Defendant's petition. Application filed under order 7/11 Lord 2026.
What is the suit for?
Suit Lord for declaration and injunction.
Oh.
The brief facts Lord leading to the filing of the suit is the plaintiff Lord claims to be the owner of the property Lord comprising survey number 17/7, measuring 2 acres 6 meters. The defendant number 1 Lord is the owner of the property in survey number 17/6, measuring 2 acres 4 meters. The claim of the plaintiff is that she has got the said the suit property 17/7 in a compromise petition that had taken place between the family members, and in the said compromise petition, the property of the defendant number 1 is shown to the southern side of the plaintiff's property, whereas in the 11 is sketch map prepared by the department ADLR, her property is shown to the west. Therefore, she comes before the civil court challenging my sale deed, which is in respect of the other property. I have nothing to do with the suit scheduled property. My I am the defendant number 1 is the owner of 17/6, 2 acre, 4 meters.
Please come to your petition and that application and order 7/11.
That is in Dharwad.
What is to be done now?
I'll file.
This is matter on under the same head. This is matter on 10th of December. Yes, next.
This is matter
You heard the other day, no?
Yes, whether now the other defendant, only you're one of the defendant.
Yes, whether allowing of my application would amount to partial rejection of the claim is the question. It may take about 15-20 minutes if it is convenient to me.
Tomorrow?
Yes.
Then we'll have it tomorrow. Yes. After?
Second set.
Tomorrow it is not possible. Tomorrow the court is raising early. Then, we'll have it on 10th of December.
Please, sir.
Yes.
This is matter on 10th of December. Next. Hmm?
Wife and children petition matter.
They're not appearing.
They are not appearing. These two,
You please argue.
please file. Well, in this case, I have filed memo. First, I have filed memo.
No. Seeking enhancement or the dismissal of the wife's petition.
No, my lord, enhancement.
How much is granted?
8,000 is granted
To the wife.
to the wife.
And how much to the daughter?
Daughter is married and it was dismissed. And petition number 3, till attaining age of majority.
It is
and now
unknown
he has
only with
attained-
regard to wife.
Only regard to wife.
What is
And in the
husband?
petition, your lordship, in the petition, you have claimed 8,000 as a maintenance because for the petitioner number 1, your lordship, that is the wife. And now I have filed an application for the amendment of the petition because at the time of filing the petition, she claimed 20,000 for herself as well as her children, your lordship. Now the petition number 3 is studying in the become
No, we are not. Now, how can this be considered now? We are in the revision in RPFC against that order. We are looking at it whether that is right or wrong. How will you seek enhancement of it before this court?
I want to amend the petition, your lordship, because she has claimed 20,000 as a maintenance,
No.
total maintenance.
Okay, how is it possible? We are only looking at it whether such an order is right or wrong. You can't seek amendment before this court.
Amendment of the petition because.
No, you find what is the implication of it? Now, again, everything has to be looked into. If you are seeking amendment of the plaint, I mean your petition, then what is the husband's capacity? What are the other things? All have to be looked into.
He is serving as a conductor, your lordship, and he is having a salary of 37,581 in the month of March 2022, your lordship. And 8,000 was awarded to the petition number 1.
No, you will be asking money as per your requirement, not as per how much your husband's income is. And you felt that you want 8,000, you asked. No, because
it is true, my lord. What has happened at the time of filing the petition, she had contributed herself for 8,000 and her children for remaining the 11,000. 12,000, and totally she claimed for 20,000 as a maintenance, your lordship. And now the petition number 2 is married and petition number 3 is attained the
court
age.
Court already granted what you have asked for.
It's true, my lord.
So then you can't file this petition at all. Technically.
Technically, it cannot be, but
And you can't amend it before this
This
court.
honorable court has
You
got
can't.
discretionary power.
No, we are every discretionary power under 226 we can't exercise in these matters. What is the jurisdiction of the court? Exercising revisional jurisdiction. Please come. The petitioner is agreed with the order passed in criminal miscellaneous number 222 of 2018. 222 or 53, which is yours?
52 is filed by the respondent.
222 of 2018 dated 20th December 2022. Whereby the court had granted an amount of rupees 8,000 to the wife and 5,000
To the son. Petition number 3.
to 5,000 to both the
Petition number 3, 5,000 and the wife 8,000.
only one son.
Only one cell, and one daughter is, it is.
Petitioner number 3, an amount of rupees 5,000. Now it is submitted that petitioner number 3 has already has attained majority, and as far as the wife is concerned, that comes for the petitioner submits that she is seeking enhancement of the maintenance. It is a case that the husband is working as a conductor in the what is KSRTC, in KSRTC, and is earning more than 35,000 per month. Next paragraph. This court has perused the order passed by the court. The maintenance that is sought by the petitioner for herself is 8,000. That is already granted by the court. She cannot be agreed by such order. When counsel submits that, she may permit, she wants to, she has filed a petition, already filed a petition, or she filed a petition. And
Filed an application for amendment.
filed an application seeking amendment of the petition. And she may be permitted to amend the same, and seeking a note, she wants to seek maintenance of 20,000. It is submitted that this court having ample power to allow such applications. Next part, having heard the counsels on either side, having heard the counsel for the petitioner, there is a material on record. No, there is no representation on behalf of the respondents from the last couple of occasions. When the wife had sought for 8,000 as maintenance to her, and the same is granted, she cannot be an aggrieved person, and she cannot file a file a petition before this court. And this court, while exercising the revisional jurisdiction, will be looking at the legality or otherwise of the order. And even before this court, she cannot be permitted to amend the petition by the way of this application. Is that clear, the matter? The petition is dismissed. Yes, next.
Matter pertains to shifting of a liquor license holder.
First of all, that provision which you are trying to take shelter under, the court will give the finding on that.
Only one additional submission on that aspect, Your Lordship. These rules have been in operation since 1967. Rule 5.1 is a main provision which decides or which directs how to grant license and in what aspects. Now, my humble submission would be Rule 5.4, which gives discretionary power to the commissioner to direct shifting of shops, liquor license holders, on subsequent erection of these schools or objectionable places, as they say. My humble submission would be, since a proviso was inserted in the year 2017, and for the fact that Rule 5.4 is continuation of Rule 5.1, my humble submission would be, these conditions in 5.4, Your Lordship, would come into operation if the liquor license have come into existence after the specified date. So therefore, had the government thought of giving protection to some liquor license or some liquor shops, they would have specifically mentioned, the legislature would have specifically mentioned that clause here. Therefore, my submission
No, in every case, in the year 2016 itself, there would be a license for that. So many people will come into that. Now, what is additional clause about? On that year 2016 itself, that whatever that prohibited thing is there, either the institution or whatever it is, should also exist on that day.
No, my submission would be,
If that is not the submission, if your submission is taken, then what will happen to Rule 5? God only knows, or they should know.
in that case, my humble submission would
No, something very mischievous one which they have made and without application of mind. The court, while exercising jurisdiction under 226, cannot interpret it in such a way.
Because in that case, the government cannot take benefit of its own wrong and then do wrong to a person who has already been existing. My submission would be, I am lawful.
Now, if had that so and so be not there, then what would happen?
So,
That amended rule is not there.
then the government would have been correct in asking me to shift my shop.
That's what. Now you're just harping on that particular amended one. Now the court will interpret it what it is. Is dismissed.
Request.
This petition is
40?
Uh, In this petition is challenging the order passed in criminal instance.
Where is other side?
Not always, no contact details.
Oh, part heard.
Last occasion,
Look at that. Look at it.
Last two occasions also the matter was adjourned because of the absence of the responding counsel.
No, it doesn't appear so. Why is it in part heard? When was it posted for part heard?
On the last occasion,
No, there is nothing on the. Where
on
do
the,
you get
under
it?
the head of part heard.
What is that? Where is that? Then counsel the petition is present, this matter on premises. We'll see tomorrow. No representation by the respondent given today
I
also.
need to be heard tomorrow, my lord, even if the
Yes, tomorrow. Yes, next.
Serial number 49 action. Preliminary hearing dispute matter. Serial number 50 RHFD government advocate.
In this matter, there is a violation regarding 541. They have issued, as per, they have approached the KAT also. KAT is directed to file a fresh representation to the authorities. They have filed without any explanation. And my lord has directed me to last occasion to get the records, whether the school or building or anything are established. It is the case in the appeal itself, it was confirmed there was an established schools and the hospital and the Anganwadi schools. Hence, it was rejected.
No, on the last date of petition, the Deputy Commissioner was very much present before this honorable court. And he has expressed, as conveyed to me, since I was not present on that day, that there are no objections and there are no buildings or the schools or colleges or hospitals are existing within a distance of 100 meters. On the last occasion, the honorable court was pleased to direct them to furnish fresh report memorandum. And as per their say only, no such buildings are
That is for serial number 54, madam. That's
We are on serial number 50.
50 and 54 in both the matters.
in 54, his statement is correct.
Deputy Commissioner appeared before this court and also instructions were given to the. What he said that day was like, that is, the no notice is given to him or something he was saying on that day.
No. In 54, that statement is correct. In serial number 50, there is an appellate order. They have given direction them to file an eviction at page 22 can be seen.
Page number?
22. Their appeal was dismissed. Page number 22.
While the order of the first respondent of which the liberty is given to the applicant to submit his reply to the notice. What did you do after this?
We have submitted our detailed
Thereafter what
objections,
happened?
madam. And thereafter, the Deputy Commissioner has passed an order.
Where is that?
That is in Karnataka section E, madam.
That is
Page number 23.
Uh,
Wherein he has passed an order stating that there are some objections raised by some of the institutions for which you are supposed to shift the building. That is the white shop. I have taken license about 22 years back now.
so,
22 years back now. And thereafter every year.
so whenever educational institution comes, we should
No,
see
no,
whether
no.
we are part.
Absolutely, there are no institution method. For the same reason, this honorable court was pleased to direct them to furnish the report membership as to existence of any building within a
Where is that?
span of 100
When
meters.
is that passed? Please shut
In
the
both the
door.
matters, madam.
No, not in both the matters. What is this order? This is matter, by the time the instruct, this is not that. In the light of the above, the respondent shall file statement of objection,
Yes.
specifically adverting to Rule 5 of the rules within a period of 2 weeks.
Statement has been already filed.
I said again,
Yes, no,
after this order 21/10/2024, 22/5.
we have issued the documents were made yesterday and last week they have submitted the documents saying that all the villages have given a complaint. Complaint has been given.
When I said-
They said it is disturbing to the public. That's why they have passed this order. And also for that, they have approached the KAT. KAT is also directed there.
It's the government period.
Please,
21/10/2024, then an order is passed.
by this amendment.
Yes. Where
To
directed
file-
you
to
to
file a
file your
person.
objection
Further, sir.
for adverting to Rule 5 of the rules within a period of 2 weeks from today. After that, have you filed the objection?
No, no.
Why not?
I will get records for that. They have given the documents.
When an order is passed, you are bound to follow it. You can't interpret it.
On 7/11, they have given the documents.
As per the order of this court, exactly what are the objections of the respondents shall be filed. This is matter on
9th of February. I will file
13th
detailed
of,
statement.
13th of December.
Please.
Meantime, may I submit my
Enter board earlier granted is
Yes,
extended.
in the meantime, may I submit? As per the provisions of law, it is Excise Act, within a distance of 100 meters, there shall have to be some buildings or objectionable structure. Let them submit a report to the extent stating that there are any structures.
By the time the objection shall contain, what is the exact distance between the petitioner's shop?
Yes, ma'am.
Petitioner's shop and the
The persons who have objected.
from the petitioner's shop to any of the education or other prohibited structures.
Please.
Yes. I have a meeting 4:48. Yes. 51. Is this matter after winter vacation? The request of non-council petition 52. Any objections? After vacation? Yes, at the request of non-council petitioner. Yes, 53. Yes, after vacation. After vacation 54.
It is also excess factor.
This can be allowed.
Huh?
This can be allowed. Petition, there is no objection.
Tomorrow 54. Next 55.
This can be.
55. After vacation. Yes. After vacation. After vacation. After vacation.
Please.
Intermodal, in all these matters, wherever intermodal is there extended, 57, then 56. 56, this is matter on 11th. Yes, 57. After vacation, 57. After vacation, at the request. Huh?
61, I told you.
Huh?
61.
No, it's 59 is called. After vacation, 60. At the request after vacation. Huh?
He is not keeping good health. He is
That's why after vacation. Monday court is not sitting.
Allah, court sitting illa.
Huh?
Monday illa.
Use the mind.
Thereafter, madam. Thereafter.
This is matter on 18th of December.
Please.
Yes, next. Huh? Huh?
5th December.
5th December. This is matter on 10th December.
Lords, it may be then. refer to mediation, my lords. He is ready to take back the wife also, my lords. Not possible.
Tomorrow it may not be possible. This is matter on 9th of December. Yes. At the request of-
On 10th, my lords.
On 10th. Yes. Huh?
34.
Huh?
In the case, I have paid me 4,000 rupees. Every month I am paying the 4,000.
What has happened to that matter?
They extended. That I was.
What has happened to
I was
that?
deducted in quota number 5. 4.
What has happened to that?
34 that is simply adjourned, my lord. Stay has not been.
Interim order already granted is extended.
30.
Any-
My lords, may I make submission? Yesterday, my lord, serial number 42, Cooperative Society Management on section 125. Lord, this is the interpretation of the matter by your lordship. This is the first lord judgment of this honorable court. If my lords feel appropriate, it is reported, my lord.
Yes.
Please.